November the 17th, 2015. My name is John Michael, work with the Metro Codes Department, and I will be presenting cases to the board for their review in today's public hearing. At this time, we ask that you please silence your cell phones and the rest of yourselves so that the board meeting will not be interrupted. The procedure for this meeting will be to introduce the case record. We will present site plans, photographs, and maps of the properties for all of today's cases. The board members also receive correspondence that was submitted in support or in opposition to these cases, as well as correspondence from other government agencies or elected officials. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those who wish to speak in support of the appeal. If the appeal has opposition, the board will then hear from those parties. After the opposition has presented its testimony, the appellant will have a period for rebuttal. The board, in their rules, provides appellant 10 minutes for the presentation if no opposition is present. In the event of a contested case, the board provide 15 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 15 minutes. Of note, for cases where there are multiple individuals wishing to speak in support or opposition of a case, time should be divided among those parties in advance, as the board will not be left to determine who gets what amount of time. All section numbers that we refer to come from the Metropolitan Zoning Code. Zoning Code was adopted by the Metro Council and became effective on January the 1st of 1998. The Zoning Code applies to the entire jurisdiction of the metropolitan government. I'll introduce the entire Zoning Code and make it part of today's record, thus dispensing with the reading of individual sections. The Zoning Code requires a record of these proceedings. As our BZA meetings are taped for Metro Channel 3, it's imperative that anyone addressing the board come forward and speak into the microphone. Speakers should identify themselves by name and address and then make the desired presentation. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. At the conclusion of each case, the board will deliberate and place their vote on that case. The board is vested with the power to act on these cases before us today under the provisions of the Metro Zoning Code, Section 17.40.180. The Zoning Code requires 4 members of our 7-member board to establish quorum. We have 5 present at this hour and expect to have such throughout the day. The code also requires that at least 4 affirmative votes are passed in order to grant an appeal. In the event that only 4 members are present and the appeal fails to receive 4 affirmative votes, the appeal shall be re-advertised for the next available public hearing cycle. In the event that 5 or more members are present and the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved property owner may request a rehearing within 60 days of the public hearing on the subject case. Additionally, aggrieved property owners may appeal board decisions to the Chancery Court within that same 60-day period. After that time elapses, the board's decision becomes final and no further action can be taken. For today's appellants, if your appeal is granted, you are required to obtain the permit for which you applied. A permit must be obtained within 2 years for a board approval to remain valid. Mr. Vice Chairman, I submit that all the cases have been filed in proper order, all appellants have been properly notified by certified mail, and all notice requirements have been fulfilled as required under the Metro Zoning Code. At the beginning of our meeting, we seek to recognize and call forward any elected officials, namely Metro Council members, who may wish to speak on any of the cases present today. Seeing only one, we'll call forth Councilmember Brett Withers.
We actually, I think, do have 2 council people. It's kind of hard to recognize because we have some new faces. And, 3.
We'll ask Mr. Withers to step forward first and then call the next ones thereafter. Please, if you would, Mr. Withers. Thank you.
And congratulations on your election to the Metro Council, and we look forward to seeing you in front of us at any time you wish.
Thank you so much. As a neighborhood representative, I have appeared before this body in the past. It's been a little while, but I appreciate the service that each of you brings to our city and our county and the time that you expend hearing cases on behalf of our citizens, and just appreciate that service and look forward to working with you for the next 4 years representing Metro Council District 6. I would like to speak just really briefly on a couple of items that are on your agenda today. Unfortunately, my schedule doesn't permit me to remain for the entire hearing. The three that I would like to speak to just really briefly, the first one is item 2015-057, which is in Council District 2. This is for a use regarding a cash advance. I had the opportunity last year as a neighborhood representative to work with council members Jacoby Dowell, Karen Johnson, and Fabian Bedney, who were working on some legislation in the county to place some minimum distance requirements between some businesses that are affected by cash uses and title loans and things like that. That legislation worked very hard to ensure that the rights of those business owners to continue that business are respected, while also seeking to find a balance in our neighborhoods about how many of those businesses are gathered together and what the cumulative effects of that are in a neighborhood. So I would encourage you, as you hear that case, to just remember the spirit of the Metro Council in trying to find a compromise, and that compromise was set forth in Bill number 2014-908 by those three council members.
So are you saying that you are against the bill, the agenda item that we are going to hear today?
What I would encourage the Board of Zoning Appeals to consider is that the overwhelming, I think, response from our communities is that maintaining a certain amount of distance between that category of businesses is desirable to maintain a productive business environment in our commercial corridors.
Thank you.
The next item that I would like to speak to is in Council District 6. This is case 2015-69. It pertains to a setback issue with 1909B Truett Avenue. I had the opportunity to speak yesterday with the resident of that home, as well as with a member of the Lockland Springs Neighborhood Association. My understanding from the Lockland Springs Neighborhood Association representatives are that they are in support of the setback request at this time, seeing that the structure is already built. We have a neighbor living there now, and that the Neighborhood Association is comfortable with that request in this particular case. Neighborhoods really want to ensure that as new infill development in particular is constructed in our neighborhoods, that the builders follow accurate site plans so that we don't have this happening in the future. But in this particular case, the neighborhood does not see a benefit to challenging this request. Finally, the last item that I'd like to speak to just briefly is case 2015-72. This pertains a fence that was constructed at 1135 Granada Avenue at the corner of Granada and North 14th in the Eastwood neighborhood. The applicants are here today and some neighbors are here. In this particular case, I think the evidence will show that there certainly is a visibility issue that the fence has created. And I think that the applicants and the neighbors are beginning to speak about what some possible remedies might be. Certainly from, as a person that lives on Granada Avenue and tries to turn onto 14th, it is difficult to see coming onto 14th, and that street does serve as a venue for a large number of bicycle riders and dog walkers, as well as a bus route, even though it's a relatively narrow street. So that street has, even though it is a collector street, North 14th, it has an above average amount of constraints on the street already, and this visibility issue furthers those constraints. So what I would submit is that certainly there is a visibility issue with that fence being so close in the setback. If it is possible that the Board of Zoning Appeals should determine that there is a remedy in terms of beveling the fence or something like that, I think that might be something to entertain. However, I think that if the Board of Zoning Appeals wishes to entertain that if at all possible, a deferral might be requested to give that a little bit more time for consideration among the neighbors. But otherwise, I think the visibility issue that's been raised by codes is a very valid one.
Councilman Withers, we once again congratulate you on your election and thank you for being here. In the future, of course, we always invite our council people that have something in their district or something that they care about to come here. But we, of course, you could write us a letter if you are not able to attend and tell us your views on a particular issue. So thank you again.
Thank you for your time.
Hello to all of you. This is my first time before you, and I'm glad to be here. But also speaking...
Excuse me, Councilman.
Yes.
You know, since you're newly elected, please introduce yourself for the record in Channel 3.
I definitely will. That gives me the opportunity to be brand new. But I am DeCosta Hastings. I am the councilman for District 2, newly elected.
Where I grew up. Very nice.
Last term, but glad to be here and to speak to everyone that is here. And I know there is some interest of, actually, Mr. Withers just talked a little bit about what's going on in my district with the Tennessee Quick Cash. There is a Metro code that is 13-7-2073. There is also the area of financial gain, which we understand what the Tennessee Quick Cash is doing. The people in my community, I am hearing this continuously, that we don't need another check cashing or quick cash facility that's in my district. That is one of the main reasons that I made sure that I was here today. And we're inside of that code. The code is speaking about the harm to public. Again, the identity and what is attached to the Tennessee Quick Cash, because most of the people around in our population are finding themselves using that source as a banking system, and we do not want to continue that cycle inside of District 2. We're also looking at the design of the current facility. The facility was built for a gas station. That's also in the code, and they are changing the design for a quick cash facility, and that is something that we highly speak against. And the integrity of the operation. Of course, business is business. I'm a business guy myself. I own my own business, and we understand that we want to do things for profit, and we need to do things in a better way. But also Shelby County in our great state here of Tennessee and Cordova, they operated, they had somewhat of the same issue, which their system voted against that. And there are, and the printout is in July 27th of 2015. So any references that we need for the sake of keeping the integrity and bringing our community up, we need to do so. And I ask for your support, and thank you guys very much, and I look forward to working with all of you and everyone that's here.
Yes.
Thank you.
And once again, congratulations. I understand that you had a 7-person council race, which was the largest.
It was a lot. It was a lot.
You did a lot to get
over.
here. So we're glad you're here, and we hope to see you in the future.
Yes, sir. Thank you very much. Hey, man. Step on it.
Good afternoon, Commissioners. My name is Freddie O'Connell. I'm the newly elected council person for Metro Council District 19. We have a couple of cases on today's docket. One of them is one that I expect I will speak on, but I wouldn't be surprised if this is one of the bigger projects that you all have seen as a board. It's case 2015-70. I honestly believe that having received new materials both from residents of the area near the parcel as well as the project team as I walked into today's meeting, I think I'm going to do my best work if I listen first, take some time to think, and then speak on behalf of this project. I just want to make sure procedurally, if after this moment I get to hear both the proposals and the opposition, I'd have another opportunity to speak.
Yes, Councilman, we appreciate you being here too, and congratulations on your victory as well. Though the way that we operate is we allow our elected officials to speak at the front of the meeting if they want to, or they can choose to speak during the actual time the agenda item is being discussed, or both. And we will tell the sides here, particularly if there's opposition, each side has 15 minutes. If not, each side has, the applicant has 10 minutes, but you have an unlimited amount of time. As a representative of the district, you can speak as long as you want and as necessary as you want, and it doesn't go against either side. So as we said earlier, we appreciate the council person always being here, and it does help us when you can say if you are for something or against something, or see your concerns. So, but yes, we will have you back when it's time for the particular case you're interested in.
Excellent. I will look for some time at that time.
Thank you.
Seeing no other newly elected council members, re-elected council members, or other elected officials, we will note at this point that the board, in fact, has a consent agenda. One board member reviews the record for each case prior to the hearing and identifies cases where appellants met the criteria for their requested action. If the reviewing board member determines that testimony in the case will not alter the material facts, then that case is recommended to the board for approval. We will enter into the record those cases that have been recommended, and if anyone is here in opposition to one of the cases identified for consent agenda, please raise your hand, and the case will be removed from the consent agenda and then heard in its regular order. Our Vice Chairman, Mr. Richard King, reviewed the agenda for today and identified the following cases for a proposed consent agenda. First is case number 47. That's case 2015-047 for the YMCA at 3001 Lebanon Pike, where they seek a special exception in the R10 district. Is there anyone here in opposition to the YMCA request at case number 47? Seeing none, the next case identified, case number 2015-68. For the appellant Wendell Harmer and Harold Moore, owner of the property at 1723 Joe Johnston Avenue, seeking a special exception from setback requirements. Is there anyone here in opposition to case number 68? Seeing none. We'll move next to case number 2015, number 69. The appellant and owner of the property, Mr. Ben Del Carmen, the property being located at 1909 B Truett Avenue in East Nashville, seeking a variance from side setback requirements. Is there anyone here in opposition to case number 69? Seeing none, we move next to case number 73. Case number 2015-73, Alan Clifton, the appellant on behalf of House of God Church, seeking a special exception in the R6 district to add to an existing cell tower. Is there anyone here in opposition to case number 73? Seeing none, we move then to case, beg your pardon, did I miss that? The address is 2101 Hyman Street. No opposition being present, we'll move from 73 on to case number 74. The appellant and owner of the property at 906 Granada Avenue, Sean Patton, requesting a continuation of a non-conforming use in the RS5 district for continued duplex use. Is there anyone here in opposition to case number 74? Seeing none, we move forward to case number 75. The Pleasant Hill Church of Christ, on behalf of the appellant and Robert Weaver, owner of the property, seeking a special exception in the R15 district to construct a new church. Is there anyone here in opposition to case number 75? Seeing one, we will remove that item from the consent agenda and hear it in its normal order. Next, case number 76. With the owner of the property, D3 Hickory Hollow, counsel Erica Garrison for the appellant, involving property at 5330 Cane Ridge Road in the Hickory Hollow area, requesting a variance from height requirements in a PUD district to install an 80-foot tall ground sign. Is there anyone present in opposition to case number 76? Board members, it should be noted that Vice Chairman King, in his review, noted that a condition should be attached to case number 76, that the sign cannot be digital. Therefore, the consent agenda will reflect that condition. Moving on then to case number 77, the final item of our proposed consent agenda. Rick Jones, on behalf of D&D Investments, the owner of the property at 2971 Craft Drive, requesting a sign variance in the IR district. Is there anyone here in opposition to case number 77? Seeing none, item number 77 will also be added, thus leaving our board with a consent agenda that includes cases number 47, 68, 69, 73, 74, 76 with the noted condition, and 77. What's that? Is she here to oppose?
No, she's not against it, but she's talked to her about it, but she's standing right here. You want to see what she's going to say?
In the middle of the Board of Zoning Appeals meeting? No, I do not. Yeah, no.
Let's take it up.
And which one? With the correction, case number 68 does have opposition present. We'll remove it from the consent agenda, thus leaving our board to vote on a consent agenda comprised of cases 47, 69, 73, 74, 76 with the noted condition, and 77.
Okay, you've heard the motion. We need a second.
Second.
Any discussion? All in favor of the motion, say aye. Aye. Oppose? Ayes have it. So be it.
So normally at this time, John Michael, if your case was on the consent agenda, I will say this instead of John Michael, you are welcome to stay for the exciting rest of the agenda for the BZA, but if not, you have your permit. Please follow up with the codes office, and, well, you don't have your permit. You have your permission to go get your permit. Please follow up the codes office, and they will take care of you, and thank you for being here.
So we'll call our first case, come to the table, have a seat.
Okay, board members, your first case is item number 57, item number 57, involving C8H Properties, owner of the property at 3100 Dickerson Pike. This is what's been referred to as the Speedy Cash case. Located here on your zoning map, you'll note that the property is in fact in the CS district there at the intersection of Broadmoor and Dickerson Pike. This aerial photograph gives you some idea of the layout of the subject property, again, located near the center of the screen. A couple of photos from the subject location show the property as it stood at the original time that this came to the board, but was brought to a later hearing date. From multiple angles looking up both of the major streets, then these photographs showing properties more across the street from the subject property. Again, the case brought to you is an Item A appeal of the zoning administrator's decision to post a stop work order on this property located in the CS district. It's referred to the board under section 17.40.180A.
Okay, before we get started, let me say congratulations to our newly elected mayor, Councilman Berry. Congratulations to her, and we wish her every success for the benefit of our city. And thanks, too, to our former outgoing mayor, Carl Dean, for the goodness that he's done for this city. So, that said?
Yes, and I would like to second that. Many people at home kind of wonder how we are up here. We are appointed by the mayor. So Mayor-elect Berry will be appointing people to this board and all these other boards that you see on Channel 3 and some that aren't on Channel 3. The mayor appoints them, and then they're approved by the Metro Council. And it's a privilege to serve the city. It's a privilege to serve the mayor, and we take this very seriously. And like I said, the inauguration of Mayor Berry will be a week from Friday, so stay tuned.
Okay, state your name.
Mr. Chairman, members of the board. Mr. Chairman, members of the board, my name is Douglas Berry. I'm an attorney here in Nashville with the firm of Miller & Martin, PLLC, and I represent Concord Finance, Inc., doing business as Speedy Cash, which is the appellant in this matter. This matter was before the board in June, on June 18th of 2015. Some of you were here and some were not. We elected to continue it to this date. The quick question, is there opposition? So we're dealing with 10 minutes time to speak or 15 minutes? Is there any opposition to this item?
Let's call. Is there any people in the audience oppose this case? Yes, there's at least one person that's going to speak in opposition, so each side will have 15 minutes for this. And the other thing is, out of your 15 minutes, you get rebuttal time. So if you have 5 minutes left after you speak, you have 5 minutes worth of rebuttal. So it's up to you how much rebuttal time out of that 15 minutes you take after the opposition has spoken.
I will try to watch the clock and take maybe 12 minutes and reserve some time for rebuttal. Let me go over this is a case that depends heavily on its facts, and I want to go over the facts again for the board. And this is what happened. Our client, Speedy Cash, entered into a lease last summer with the landlord of the property, C&H Properties, to use this site as a cash advance store. On September 15th of 2014, the Speedy Cash's contractor applied to the Metropolitan Codes Administration for a building permit, and at that time received a zoning certificate stating that the zoning was allowed the use. From September 15th till November 15th, then the contractor and architect set about getting the necessary sign-offs, if you will, departmentally, fire and codes, floodplain, and so forth, the typical approvals one would need to get a building permit. And by November 18th, that had been accomplished. There was a small delay because initially it was discovered that a portion of the building was in the floodplain, and they had to redraw the plans to rebuild on the same site. On November 18th, the architect for the project contacted Richard Thermopoulos with the Codes Administration and to check on the status of the permit. He tried to check it online, and Mr. Thermopoulos advised him that there had been a change in the code, which actually was technically not true as of that time. The Metro Council voted on the bill that night. There had been a change in the code, and that the distance restriction, the 1,320 linear feet distance restriction from one cash advance store to another, would be the new law that the applicant would have to comply with. And in his email message, which is made a part of the record, and let me say that when we initially presented this appeal, the legal staff stipulated that all the facts contained in the appeal were correct. I assume they still stick by that. But in that email, it stated, since you initially started your application, there has been a change in the code. Your application did not grandfather you in, and you now have to comply with the change. Pretty clear message, pretty clear decision had been made. It's November 18th of 2014. Subsequent to that, a gentleman named Mr. Zachary Nofall, who was actually had been a tenant of the prior, a partner of the current tenant, came to the Codes Department about a week later and inquired about the status of the permit for the Speedy Cash store. And at that time, Mr. Thermopoulos looked up the history of the permit on his computer and advised Mr. Nofall that the permit should not be affected by the new law because the resubmitted plans had been signed off on and that the permit was grandfathered. Mr. Thermopoulos then went to check with his supervisor, the chief zoning examiner, Joey Hargis, a lawyer, experienced zoning lawyer, and Mr. Hargis approved the issuance of the building permit on November 26th. Now, the other timeline that's proceeding on here, parallel to this, is the bill was introduced in the Metro Council on October 7th to create this distance restriction, and it did pass went to the Planning Commission sometime in October, and then received a positive recommendation and went to the board and was indeed passed into law on November 18th. No question about that. And there's no question that all parties were aware of the pendency of the ordinance. We don't dispute that. But now we've got a codes official formally advising the property owner or the lessee, the long-term lessee, my client, that they indeed do have the right to a building permit. And then after talking to Mr. Nofal, who was sort of unofficially there as the landowner's agent, Mr. Thermopoulos called Mr. Jeffrey Hitz, and I neglected to introduce my colleagues here. Jeffrey Hitz is with Speedy Cash Parent Corporation, and then Mr. Chris Darnell as well is with the real estate side of their operations. And he talked to Mr. Hitz, and he said you would have a permit, and the only condition would be that you didn't change contractors. So not only were they, it wasn't like somebody said it's a Thanksgiving vacation, I'm going to go sign this off, let's all get out of here. They thought about the permit enough to say there is an additional condition, you don't change contractors, which of course Speedy Cash did not do. So in the ensuing time frame, December 2nd through April of this year, 2015, Speedy Cash expended $570,000 in reliance upon these officials' issuance of the permit. In addition, the landlord, C&H Properties, spent $37,000 removing the fuel tanks and fuel islands from the convenience store site. Now, I don't know what the objection is about the design. That's really not an issue before this board. I didn't quite understand why that's objectionable in some way, but that's an expenditure of money that wouldn't have been done. So we've got over $600,000 of money has been spent because of, in reliance upon these decisions. 3 days before the store was to open, Mr. Herbert, whom I deeply respect, but as a colleague in person, made a decision to issue a stop work order and to not essentially rescind the building permit and say you can't use the site for what you'd intended. Let me say there is no other use for, as far as my client is concerned, there is no other use for this site. It's been adopted to a Speedy Cash convenience store, a Speedy Cash cash advance store. They will basically have to walk away from the project. There has been a use and occupancy permit has now been issued by the metropolitan government, so everything is awaiting a decision on this zoning question. The theory on which we're proceeding is called estoppel. And what estoppel says is closely related to the theory of vested rights, another legal theory. And what estoppel says is when the government, city government, or one of its officials makes a decision, even if it does not comply with the law controlling at the time, the city is estopped to deny the validity of this act for equitable considerations. Equity means fairness considerations arising on the facts of the particular case. And that's important because this is not, I know I've advised boards like yourself, and there's always a worry about setting a precedent. But what's very important is that a decision like this, it depends on the facts of this particular case. I'm not sure you could repeat the facts of this particular case if you wanted to. Keep that in mind, please. And the city will be estopped for equitable considerations arising on the facts of a particular case, usually because the city has accepted benefits of an act. That's not the case here. It induced another to perform, or because the city induced a detrimental act of another. It's our position that the actions of the codes officials induced a detrimental reliance by Speedy Cash, and then an estoppel is created. It's an exceptional set of circumstances which warrant the application of the doctrine of equitable estoppel. I understand that. One of the questions we received last time, a good question from either Mr. Taylor or Mr. King, was whether or not this board could consider equitable principles in making its decision. And I would answer that in the affirmative. This board and other boards of zoning appeals have considered equitable estoppel type cases or vested rights cases. They're closely related. There was a case, I don't know whether any of you were on the board at that time, dealing with the adult business located next to a Salvation Army church in 2009 or so, where equitable estoppel was one of the issues this board made its decision based on. Now, what subsequently happened to that case, I don't know, but the board didn't say, no, we don't have jurisdiction to hear that. And if you think about it, boards of zoning appeals, when you consider variances, when you consider expansion of non-conforming use, you're making judgment calls that are beyond the black letter of the law all the time. Considerations of equity and fairness are part of what this board's jurisdiction is about. This board provides a quasi-judicial tribunal for questions that arise under the zoning ordinance. You're acting like as close to a court as you can at the administrative level, and that's why I think shouldn't be a.
Let me interrupt you.
Yes,
You said that you wanted to reserve some time.
Oh, thank you, Mr. King.
And
I
you
got
have
about a
like
minute.
4 minutes and 50 seconds.
All right, I don't know.
So
I don't know what the opposition is going to be. Let me. Thank you. Thanks for the reminder. Let me I'll just follow it closely here. One thing, another concern that one of the board members had was that if we rule one way, we'll be sued by somebody, and another way, somebody else will sue us. And for that reason, and we do have a letter now in the record from Advanced Financial, which is the other cash advance store affected by this distance restriction, who might have had a standing, if you will, to oppose this application. And they have now formally said, file with this body, that they do not oppose this application. So that potential lawsuit, if that's the concern, is not out there. Now, I know we have before the Tennessee Supreme Court right now the issue of whether the metropolitan government may appeal its own board of zoning appeals. I guess I don't know what hope that has no effect on your deliberations. But like I said, this is a rare set of circumstances. It's not one likely to repeat itself. It's rare that you see a good case for equitable estoppel. I really think this is such a case. And let me say, the use, whatever the policies behind the ordinance, this is still a permitted use under your zoning ordinance. It's still a lawful business. There could be other uses which are, perhaps less controversial, like a candy store or something. I don't know. But this is a permitted use under your zoning ordinance. And for that reason, we don't think that's a valid consideration. So let me stop and reserve my time now.
So I want to tackle this point, which doesn't go against your time, but before we get to your rebuttal, because when we do rebuttal, we want to stick to issues brought up. I want to talk about the equitable and this board being or not being a board of equity. My understanding is you were challenging the administrator's decision or action.
Correct.
And let me just disclose I'm not a lawyer by any means. I'm barely an architect. We are to decide whether or not he was in error.
Right.
So I'm not sure how we get to what the effects of his decision, whether we take your side of the argument or his side of the argument, what the effects of that are. I'm not exactly sure how that matters, simply in that it's a fact of was he wrong or not. I know that's maybe subtle, but I'm not exactly sure how the effect of the business post the decision, I'm not sure what that has to do with whether it was the right decision or not. Could you opine on that?
Well, I would say it has everything to do with it. There's nothing in the zoning ordinance that really, for example, says when the zoning administrator may or may not revoke a permit. That's a discretionary decision he has. So once again, you're bringing principles to bear that are not black letter parts of the zoning ordinance to say this was right or wrong. And we would argue that, they're not saying that you're a board of equity, that would be stretching it a bit, but I'm saying that it's perfectly proper for this board to consider equitable principles just as it considers legal principles. When for example, if you're making a decision on a variance, you consider, is there a hardship? Well, that's not a hard and fast legal standard. That's something where you think what's fair, what's a hardship here. So I understand your concern, Mr. Harper, and it's an interesting question you pose. But I would say you certainly may consider that in deciding whether or not Mr. Herbert acted in error in stopping the work. And rescinding the permit after so much work had been done. And there was no question about that. No dispute that Mr. Herbert knew the various Metro departments that made inspections after construction commenced, 3 or 4 inspections and further permits issued. Nobody said one peep about, hey, you need to stop this. This is in violation of that zoning ordinance we passed back in November. So I hope that's responsive. Thank you.
Okay, you have 3 minutes and 29 seconds left for rebuttal time.
Mr. Chair.
Yes, sir.
I think it would be appropriate, as the zoning administrator, it is an item A appeal, just to briefly state what my position is and why. First of all, I agree with Mr. Berry. The facts are really not in dispute. And I wrote a letter that is in the packet that's part of the file dated June 17th of 2015. Let me just note that that letter, while it doesn't have my signature on it, I'm validating it as my letter. It was a computer glitch. I couldn't print it, and so if I couldn't print it, couldn't sign it, blah, blah, blah. So in any event, this is my letter. So in the letter, what I state and what happened was I was not aware of any of the facts that were transpiring during the course of these events. They were handled at a staff level. I was made aware of the situation when it was brought to my attention that the permit in this case had in fact been issued after the date that the ordinance had become effective. So that on that basis, what I then did was, in recognizing the fact that truly I felt that there was some equitable principles at play here. On one hand, I had equity. On the other hand, I had the fact that the permit had been issued after the date that the ordinance had become effective, setting the distance requirements. So I then contacted the legal department and asked for their advice. And the legal department looked at it and got back with me within a day or so, and it was the opinion that the stop work order should be issued. So I followed the advice of counsel. Let me say this, that again, I'll say that the facts are not in dispute here. And quite frankly, I can see it both ways, really.
What was the legal counsel that you consulted with the same as our legal counsel?
Not the same legal counsel that we have here today, no.
And speaking of which, I see many Metro lawyers in the room. There's someone sitting next to you that's new to us, so could you please introduce her and put her on the spot for us?
This is Miss Emily Lamb. She is our Metro legal representative here for today, and I know that Miss Lamb is representing the Codes Department now. She's been assigned that glorious duty. So welcome. Thank you for being here.
So, Ms. Lamb, Mr. Berry has made this equitable estoppel argument. I've been on the board for, a while, and I haven't really seen a case that is this far along that we kind of then say, oh, we made a mistake, we shouldn't have issued the permit. So what is your stance on this particular issue, and do you agree with that this business should not be allowed to operate because of this duly passed law of the Metro Council?
It is our advice that equitable estoppel does not apply to Metro government in this situation. The permit was issued in error, and therefore I believe Mr. Herbert did the right thing in revoking the permit. And so it's our position that equitable estoppel does not apply to this.
Not to get into a kind of law school-like argument, but, to me, this is almost a perfect case for equitable estoppel, that the permit was issued by the government, and the client apparently had no reason to think that it wasn't valid, and then literally at the very last minute you say it's not. Why doesn't equitable estoppel apply?
Well, I think in looking at whether or not equitable estoppel applies to the government, as Mr. Berry said, you have to look at whether or not the government induced action. It's our position that we did not induce the action. There's a difference between inducing versus acquiescing or just not I don't think we actively induced them to go out and
So when,
build this or do
when you
build out.
hand someone a permit saying you could build a check cashing store, what do you expect of their client?
Well, I think that they were on notice that because they had talked to Mr. Thermopoulos the week before, and Mr. Thermopoulos had told them that the permit would not be issued. So I think they were on notice that the permit shouldn't have been issued, so they could have at least, or should have rather, followed up to confirm that the permit was in fact valid. When they didn't do that, as soon as it came to the attention of the zoning administrator that it had been erroneously issued, he, as soon as he found that out, he let them know that the permit issued the stop work order.
I'd like to give the thoughts of someone who's a design professional who does have to assist the contractor with obtaining permits. And when we submit our plans to Metro Codes, and for them, I think it was September 15th.
September 15th, yes.
A lot of work has been expended by the architect, the civil engineer, what have you, on behalf of the owner. And that to us is when you get a permit tracking number on that date. And so you're vested in that. And I believe you said October 4th or 7th is when the ordinance went into effect, or the ordinance was introduced.
Introduced, I think, or at least introduced or passed first reading on October the 7th.
Yeah.
Right.
And so when they went and got their permit tracking number, they were not aware that the ordinance was even going to happen. It hadn't been introduced to Metro Council yet. And so I just wanted to bring that up because you're asking about Metro's position, but there's another position here that affects the design community as well. And I just wanted you to be aware of that.
Let me stop us here. I think we're boarding on deliberating the case right now, and I think we're ahead of the game.
But Mr. Herbert had given his position, and I think we're just trying to suss out some of those issues.
But don't we do that in the deliberation?
Well, I mean, he's a party to this.
I just wanted to put my position and why I did what I did on the record. So that was the only reason that I wanted to interject. But it is an item A appeal, and I wanted to state that I truly don't think the facts are really in dispute here. I think it comes down to whether or not this is there's an equity remedy available here or not.
And Chairman, one of the reasons I would like to follow up with these questions is so that the appellant could address them on rebuttal if they so wish. Otherwise, they wouldn't be able to.
Okay.
If that's okay. So, if Ms. Lamb, what is the Codes Department's position as far as legislative action taking place once it's been? How do they deal with a proposed ordinance change before it is changed, but it's been introduced? Do you go on the assumption that it will be passed, or nothing matters until it's passed? And I'm asking that, I guess, from more of a legal standpoint.
I might be misunderstanding the question, but with respect to, I'm kind of combining that with what you said with respect to vesting. And in order for this to have vested, it would have had to have been a validly issued permit, which it was not a validly issued permit. It was issued after the ordinance had passed. So, I mean, they had started the application process, but they had not received their permit.
What was the date the permit was actually issued?
The permit was actually issued, I believe,
December 2nd.
December 2nd, and the ordinance passed November 18th is when the ordinance passed, third reading.
So these folks applied for a permit, and between the time they applied and received the permit, an ordinance was introduced and passed. So if we vote in favor of the appellant, what would be your position to the Chancery Court to say that we should have considered that they had introduced this before the legislative process even started? I'm not a Chancery judge either, but I can tell you I would be pretty upset, I think, and unless you have a case that says, no, we do this all the time.
And here comes another Metro lawyer. Please introduce yourself.
My name is Susan Jones, and I represent Board of College. Usually I'm sitting over there, so I know how to hit the button when I'm sitting there. I'm out of place today. I'm actually not advising the board today in the board's decision because I am the lawyer that advised Mr. Herbert on the issue when he sought legal advice as to what he needed to do under the circumstances. Now, if I understood your question correctly, you were asking what our position would have been as it related to any ordinance that had been introduced but had not passed at the time the application was made, or even if the application were made, then the ordinance were introduced but had not passed. What's our position on that? We typically take the position that the pending legislation doctrine applies. After second reading and after the Planning Commission has gone back and given a recommendation, we take the position typically that the ordinance is now pending, so there can be no permits that are issued that would be repugnant to the ordinance that is at issue. So we would have taken the position that even before it passed, it would have been improper for the Codes Department to have issued the permit. And certainly afterwards, the legal department was not in a position to tell the client to violate the code. So that was that's kind of the back history of it, and I hope that answers your question. And I felt more like that was not, I'm trying to allow counsel to answer the procedural questions, but for the substantive questions, I actually worked on that issue, so I'm happy to answer those for the board if you have any more.
So I don't want to conflate anything here, but are we saying that that was the initial error that was made in, or the opposite of that? Because I see this doctrine, even though this wasn't introduced in the middle of that proposed legislation, it was introduced before, would the pending legislation doctrine not apply?
The pending legislation doctrine, I'm sorry.
Or am I misreading, or am I misunderstanding what you're saying?
The pending legislation doctrine would have prevented the issuance of the permit normally. That in and of itself is what makes the permit having been issued in error. That's the...
Even though it was applied for before, I guess
correct.
In a way it's sort of a mirror image of the doctrine.
And that's correct. And the reason that is too is because there are examples of legislation where the council, when they don't want it to apply to applications, there has been legislation that has stated that to any applications that are currently pending, that they're allowed, or where I think there has been legislation both allowing for the time period in terms of the effective date of the ordinance to allow any applications that are already pending to kind of go through the process. I think that's what actually has happened in the past. I don't know
if they don't, if council doesn't actually specify that, is there no grandfathering?
No.
By not even state law?
Now, I will say this, there has been a change in state law. The 2014 Vested Rights Act came into effect in 2015, which would give some assurances with regard to any building permit or any preliminary plans or anything like that that have been approved by the government. Those apply to anything that has happened after January 1, 2015. That was not in effect at the time. Right. Had it been in effect, perhaps we would have a different case here. It was not, though.
All right. Hope it didn't take us too far down the rabbit hole there.
I have another question for Mr. Berry.
Pardon me, Mr. Chairman, Chairman, is there opposition from that's going to speak against this other than staff? I'm sort of waiting for the other shoe to drop here. Is that?
Yes, there's one gentleman at least.
I'm happy to answer your questions, Mr.
Okay.
Go ahead.
My question, over the years during my practice of law, I've represented a gas station owner and have actually gone to underground tank school, which is a very heavily regulated process, as you know. I did pass the gas tank school test that I went to with my client. But You all expended how much money to unearth these clients and remove them?
In that case, and let me say, the landlord, neither the landlord nor the gas station owner is a party to this appeal. I brought that up really as an example of additional money. The money that my client spent in reliance upon the issuance of the building permit was $570,000.
Okay, so you were the lessee.
We were the potential lessee.
Okay.
The landlord and/or their prior lessee spent.
But they're not a party here?
They're not a party. I was bringing that up to just illustrate the magnitude, if you will, of the reliance from a dollar standpoint. And I think it was $37,000 spent to remove the tanks and remove the islands.
But your client had to spend money to take this convenience store and make it a check cashing store, which I imagine is security.
That was the $570,000 had to do with security. These gentlemen are the experts on that, but just changing the whole look of the store, security glass, I don't know whatever. It's been stipulated to. There's a lengthy bundle of invoices and contractors' information in our initial appeal, but $570,000 plus or minus is what my client expended.
And so it's really going to be hard for just another type of business, whether it be a grocery store or a restaurant, to come. They'd have to spend money to.
That would really be the landlord's interest. I mean, our interest is it's of no use to us. We're still under the burden. We still have the obligation under the lease with the landlord. So it's of no use to us other than as a cash advance store.
So if you weren't allowed to use this site for a cash advance store, you'd be just out this money you've expended.
A total loss. It would be a total waste and loss. Another equitable consideration is the courts don't like waste. So
Let's proceed again. I think we're bordering on debating the case right now.
Can you hear from the opposition?
Yes. Now we can hear from the opposition. You still have 3:29 left for your rebuttal time. So.
Thank you, Mr. Chairman.
The opposition needs to sit where you are, so you will be able to come back after they speak.
Thank you. I wish for the opposition to state their standing to be the opposition unless they're affected neighboring business. I'm serious.
Well, there's no standing requirement. I could be here just as a citizen of Nashville, but I'm not. I'm here representing Tennessee Quick Cash. The councilman who spoke got the names mixed up, you may have noticed. The appellant here today is Speedy Cash. My client is Tennessee Quick Cash, which is a locally owned.
Can you pull that microphone a little closer, please?
My client is Tennessee Quick Cash, a locally owned company with stores in and around Nashville. And they're opposing this because they've been in similar situations with the Codes Department over the last couple of years. As you know, there have been a number of ordinances passed trying to restrict these kind of businesses. And each and every time, Codes has said, no, it's what the ordinance says. The Gallatin Road Improvement District flat out prohibited these kind of stores. Court of Appeals overturned that, but Metro enforced it until they did so. But there's been a lot of talk about the $570,000. To my client, Tennessee Quick Cash, that would be a lot of money, a whole lot of money. But the appellant here today is a multinational corporation. It has stores in Europe, the United States, and Canada. I would venture to say that $570,000 is a drop in the bucket to that company. But I could be corrected on that. I'm just going by their website, which identifies them as having stores in the United Kingdom, Canada, the United States. They were founded out in California back in the 1990s. They're not going to be hurting if they have to take a loss in this transaction. So I don't think that should be one of the considerations. But even if it were, it would be an equitable consideration. And I believe Mr. Harper posed the question very well. This board, I don't think, gets to the point where it needs to make any equitable decisions in this case. Putting aside the question of whether you should, which I'll address in a moment, The issue that's before you is, did Mr. Herbert, when he posted the stop work order, do so in accordance with the requirement of the ordinance? Everybody agrees he did. End of inquiry. Mr. Herbert and this board is governed by the ordinance, and the ordinance says you cannot build these stores this close together. End of inquiry. Now, I know it's not going to be, so I will go on. But, I mean, you've got a situation here where you are going to have the ordinance, the Metro Council, which adopted the ordinance. That ordinance states a policy of why they do not want these stores in Nashville. They are bad for the citizens. They're bad for the health and welfare of the citizens of this city. That's a policy. It's stated in the ordinance, and that's a policy which you must enforce. Now, the councilman here today spoke of that, I think, to remind you of that obligation. The zoning administrator has made a decision. And if you're going to get into the equities, then what you're really going to do is decide whether or not one of many zoning examiners in Metro government can overrule the zoning administrator. Turn the question around, okay? You go into the codes department, there's 5 or 6 zoning examiners, and you draw them by lot, usually. You get up, walk in, sit down, you tell them what you want to do, and they give you an answer. Now, if they make a mistake, does that bind the zoning administrator? No. Does it bind the Metropolitan Council? No. The ordinance says what it says. Now, it's unfortunate a mistake was made, but mistakes happen. I've represented many clients where mistakes were made by departments in Metro, whether it be water and sewer, codes department, where a mistake was made. And I had one get a call several months ago where they just pulled their building permit because the stormwater division found that, oh, there's a water line down there. We missed that on the plans. And they stopped the entire project because they made a mistake. Not a thing my client could do about it, and I told him that. He was held up until he redesigned the project. That's the way it works. Is it Karpinek? Karpina. You had a question, a concern about the, the tracker, permit tracker. That's really not an issue here. What you've got to remember is, and this gets into the equities, they were put on notice in a written document, an email from Mr. Thermopoulos saying, hey, we've got a new ordinance now and you've got to comply with it. And then as the story evolves, a former tenant, Mr. Ryol or somebody, happens to be a codes dealing with some of his property that he has in Nashville. And he says, oh, Richard, by the way, what about this? How come, that you're pulling their permit or they can't proceed? And Richard said, well, let me look at it. And then he goes in, talks to Joey Hargis, and comes back and says, yeah, we think he's far enough along, he should be able to proceed. Now, all this is verbal. We're going to assume that it was said because I think all these people are truthful. But that's the kind of mistake we had. Now, what should they have done? I know what I would have done. I would have gone Richard Thermopoulos' desk, Joey Hargis's desk, and the zoning administrator's office, another 12 feet down the hallway. I would have gone down to the zoning administrator and said, is this accurate? Are we going to be able to pull a building permit here? I would have at least done that. What I probably would have done if I weren't a lawyer is I'd call Mr. Berry and say, Mr. Berry, I understand you're a zoning lawyer. How about telling me what to do here? The ordinance says this and the zoning examiner says this. What should I do? Mr. Berry or any other good zoning lawyer would say, let me look into this. We need to get this determined by the zoning administrator, not by a plans examiner. That wasn't done, all right? And that's important because where you're going to place the burden, you know that there are cases where people go into Metro departments every single day, Public Works, Water and Sewer, Health Department, to get a permit or to get some sort of approval. And they go in and they say, gee, I'm not sure they're going to give me this. But sure enough, that clerk working that desk on that day gives you the permit.
I'm sorry, Just wanted to let you know I'm an architect, so I've gone through this process. It looks like you're addressing me, so.
Oh, no, I'm not. I didn't mean to. You raised the issue about the status tracker. And I mean, I could tell you were concerned that they had, filed their initial application, and then later on they find out that it was a mistake. Well, the burden of finding the mistake is on the applicant. The cases cited by Mr. Berry, for instance, the City of Lebanon case, Baird versus Lebanon, that was a case where the mayor signed a contract. The city took the benefit of the contract and they said, we're not going to pay you because the contract wasn't approved by the council. And the Court of Appeals said, you got to pay. That's not the situation here. But let me move on to the equitable estoppel a little bit more. The precedent that would be set here, I think, is scary. It's really scary. Because if you can go in on a bad day and catch an official in one of the departments to sign off on something, and you got it, you filed your application, and they said, yep, here's the permit, then bad things can happen. The whole vested rights theory, as stated in Mr. Berry's mini brief here, is for a permit which is validly issued, and that's very important, as council has pointed out. This permit was not validly issued. It was issued in violation of the terms of the ordinance. And do I get re-rebuttal, or is this my only chance?
No.
No means I don't? Okay.
I'm sorry, did you state your name? You said you were representing, but I'm not sure you stated your name.
I'm sorry if I didn't. My name is Peter Curry, C-U-R-R-Y.
Thank you.
I'm an attorney here in Nashville. I used to represent the codes departments back when I wore a younger man's clothes.
Well, thank you for being here, and no, as you don't get rebuttal, the other side gets to speak, and then we get to deliberate.
I'm almost through it here. So again, in closing, I would ask that you, in keeping with the Metro Legal Department's advice, that you refuse to overturn the decision of the zoning administrator. Thank you.
Chairman, may I ask Mr. Curry state for the record what his standing is to appear before this board? Is his client own a store within the zone affected by the distance restriction? If his standing is just simply that he represents a competitor and has the standing of, quote, any other citizen, I would object to his standing to speak.
Well, I'll let your legal department answer that. I have standing as a citizen to speak here today.
This is not a legislative hearing, Your Honor. It's a Mr. Chairman, it's a quasi-judicial hearing. It's not a legislative hearing. There is no, quote, standing for citizens to speak before the board of zoning people.
That's what you have public hearings for.
Let me ask you something, sir.
Yes, sir.
You addressed something a little while ago. I want to be clarified here that the council did not legislate or pass that legislation with the intent to go against that particular client.
Oh, no. It was passed to apply to clients such as my own, Tennessee Quick Cash, Speedy Cash, Advanced Financial. It was an ordinance generally covering the entire county, putting in a distance requirement of 1,325 feet.
I just wanted to clarify that for the record. Okay.
Yes.
And what's the closest store do you have to this location?
This is on what street?
Dickerson Road and Ewing Lane.
We've got one further up Dickerson Road. We've got one
How
in
far?
Madison. I don't know. It's not within a quarter mile. No. I think Advanced Financial is probably, as I understand it, the only one that has a store within a quarter mile. But whether Advanced Financial objects or doesn't object has no bearing on the issue before the board. Thank you.
Okay, the appellant can come back, and you have 3 minutes and 29 seconds remaining on your rebuttal.
I'll try to make it fast, Mr. Chairman.
Hold on 1 second.
Yes, sir.
I'm sorry. Can we address the issue of standing? This has come up before, maybe not on item A, but can we address it with our legal counsel? Yeah. Ms. Lamb?
Exactly.
standing in front of the board, can anyone come here and speak basically on any issue, whether they have a economic or other potential harm in the outcome of this case?
Yes, I think that if you can prove that you have some kind of adverse interest in this, or you would be adversely affected, I think that you do have standing to speak on the issue.
Mr. Chair, under the common law writ statutes, the statutes talk about appeal on standing to appeal BZA decisions, and what they discuss is that that a person needs to show some type of harm, some type of adverse impact, some type of interest, if you would. I'm trying to reach the exact language contained in the statute, and I'm not calling it right now, but you've got to show some type of particularized harm or interest or something to that effect. And so there's been cases where it talks about distance requirement, that if you're located within a certain distance, and there were some cases that even said 2,000 feet. If you were within 2,000 feet, you automatically had standing. But then been other cases that have come down and said, no, there's no, to have standing to appeal a board's decision or to appear before a board, you've got to show that you've got some type of interest, and something different perhaps than just the general public as a whole, some particularized type of interest. The language is something along those lines.
Okay, you can proceed, sorry.
Thank you, Mr. King. Let me just renew again for the record our objection to Mr. Curry or his client standing to speak before this board. We did raise that before he spoke. It was not raised in jest, and we've made that more particular now. They do not have a particularized interest different than that of the average citizen, and therefore have no standing. And to the extent the board considers those remarks, you are going to be straying into an area of making an arbitrary and capricious decision.
But would you say that applies to people speaking in opposition to an appellant's position?
A councilman obviously can speak under your rules, but if you are, this is a Board of Zoning Appeals and not a legislative hearing. Therefore, the citizens in general have no standing to appear before this board. You have to have an interest that's affected by the decision of this board.
I thought he said that he was representing a company that is in the same industry that is supposed to abide by the rules that he's saying that your company did not because of the permit.
I don't want to argue with you. That's not. I would say that's not sufficient standing. I mean, they don't have. They didn't spend $600,000. They're not similarly situated for my client. They didn't spend this much money in reliance on the permit. I don't want to argue. I just want to preserve that objection.
I understand and respect why you would want to say he doesn't have standing, because if you know, this may get continued somewhere else if it goes one way or another, somebody may do that, and so I understand that, but we have certainly had many people in many cases say, well, I'm a neighborhood president practically on the other side of the county, and I don't want you to set precedent, but because I represent the neighborhood, and we let him speak and all that kind of stuff. So I think he's actually got a little bit more interest than that, but I understand your comment.
I don't want to take any more time with that. Thank you. As to whether our client is a international corporation and has lots of money, that has absolutely no bearing on this board's decision. I think you all understand that. Let me say this. To the extent we're trying to talk about a bad day for a clerical employee, and then somehow somebody whizzes in there and then puts a bunch of plans on there and they sign off, that is nonsense. Mr. Hargis was the chief zoning examiner. He is an experienced zoning lawyer and is now with a national law firm based on those credentials. So that is absurd to try to put that in that category. This was a formal decision made where the applicant was dealing with Mr. Thermopoulos the entire time, who in an email to the client's representative said, "You're not grandfathered." And then when someone else came in and said, "Are you sure about this?" he tells that representative, "You know, I think you were far enough along. You've got to be grandfathered." And then they didn't leave it with Mr. No-Fall. They called this gentleman right here, who is the chief of real estate at Speedy Cash, and said, you've got a permit so long as you don't change your contractor. And then the permit itself is a writing. That's the item. I mean, there wasn't going to be, hey, we're going to give you a permit, and here's your permit. The permit itself is a written document upon which any person can rely. And I've noticed the way the members of this board, based on their own experience, understandably have tried to grapple with things like the pending ordinance doctrine, vested rights, when do rights vest. And the fact is, I was a city attorney for 25 years. People are not born knowing this. People who work in this system every day don't necessarily know how to make these judgment calls on the fly. But the fact is that a lawyer told a codes examiner with lots of experience, this is okay. Our client doesn't run the Metro Codes Department. The people who run the department run that department. They set the rules. They said, we're issuing you a permit. Why in the world would Speedy Cash look behind that? And once again, and let me say, for the sake of, did want to correct the record for Mr. Herbert. I did not want to imply that he was sitting there perched and hovering over this process, waiting for the right moment when we had spent lots of money to come down hard on this. Totally agree with his characterization of what he did. He didn't know about it till up in April, and then made the decision he made in the best of faith. And I have great respect for Mr. Herbert. I just think a mistake was made when the building permit was issued. We suffered by relying on that mistake, and now it'll be a total loss, a complete and total loss of over $500,000 to no end, except we're at 400. I don't know what the distance is from the Advanced Financial Store, who, by the way, of course, does not oppose the application. I think it's like 700 feet instead of 1,300 feet. So this is not exactly 1,100 feet versus 1,300 feet. This is not exactly an urban blight creating situation if you're 200 feet closer to the nearest cash advance store than you would have been before this ordinance passed. So I think our time has expired. Thank you all for your courteous attention. It's a difficult case, and I respect that.
You're right about that. It's a difficult case. Thanks.
Thank you, Mr. Kent.
We stay here.
I don't know. Do we sit here while you deliberate?
Deliberation, shall we?
I apologize if I inadvertently started the deliberation early.
No, we're fine. We're fine. Confusing case. Who wants to take it off? You want to lead the way?
Why are you looking at me? It is a very difficult case, and what I'm thinking is, the relevance of the case of equity is something to talk about. As we look at item A appeals, and our kind of historic question that we ask is, was the zoning administrator in error? And I think just answering that question without considering any other facts, I think the zoning administrator was correct. I think the zoning administrator followed legal counsel, and the permit was incorrectly issued. And so, other than being a business person too, and having gone through the process on another side, I can't imagine as a person going through the process having to go through what they went through and get to the point that they did to have this as an error. And so maybe the question is, where is the remedy? Is the remedy here, or is the remedy somewhere else? Is this a remedy for the courts, or is this a remedy for us? And that I don't know.
Well, we could certainly come up with a remedy, and the courts could change it, which would be useful. Or we could come up with a remedy, and the courts could say, yeah, that was okay.
Well, and that comes back to the question of where's the burden, and and what I'm struggling with is an individual, is a company in good faith that did everything apparently correct according to them, and anything that I think any of us might do, and got to a point, and yet you have a very clear rule law from the Metro Council, and Metro Council people coming today saying, this was clear, this is what we wanted, and we hope you do this. And you have a zoning administrator who said, no, as soon as I found out it was an error, it's an error. And
this is an outlier case, as someone that's been around this board for a while. I haven't seen anything to this extent, excuse me, with this investment before, and now it's thrown in our laps to decide what to do. Clearly, the Metro Council duly passed this legislation. We do not question whether this is a valid law, but they were issued a permit that they shouldn't have been issued. And now the building is basically complete, and they cannot operate the business that they are supposed to, that they intended to in this space. So, if we say no, their permit that they got and no other reason why they didn't think that permit was valid is now all for naught, and they have to go somewhere else for a remedy. But like I said, our codes department, especially during this huge building boom, has dealt with, thousands of permits and buildings and people. And so this is just a real rare occasion, but, mistakes happen, and now we get to deal with it.
Yeah, and we do fix some mistakes. I mean, we fixed a mistake today on the consent agenda. There was a house that was 4.5 foot from the line. It's supposed to be 5, and we put it on the consent agenda. Not a soul objected, and I get that. And yet there's this is, So I mean, I'm really sensitive to trying to figure that out. But at the same time, you think. I mean, does it matter if it's a cash place or a donut shop or an adult business? Or, I mean, this was an industry that was specifically singled out by Metro Council and said you can't be here. It was known, and so I mean, I'm trying to figure out. I don't know. This is a tough one. Maybe somebody should just.
I have a couple comments. First of all, the business can be there if it's 200 feet away. Then it's allowed to be there. That's what I understood from the testimony. Oh, but you said it was 1,100 feet away from the current one, so if it was moved 200 feet more?
1,320 feet is the distance restriction in the ordinance. The advanced financial outlet that was within that restriction is about 1,100 feet away.
So it's about, if it was moved 200 feet over, it would be allowed.
That would be a different lot, unfortunately.
Yeah, that's a different lot, so they're kind of out of luck. They lease the lot next door. It's owned by somebody else, so.
My purpose in saying that was to the extent, and I understand the policies behind the ordinance, but to the extent you're trying to validate or honor those policies, this is just not that severe an encroachment.
So, well, here's a hypothetical. I guess it's hypothetical, but why wouldn't they just seek a variance in the setback or the separation distance? Hey, it's 1,300 feet or 1,100 feet. We're asking for a 200-foot variance. Is that not allowed?
That's not right.
I mean, I understand why they're appealing the decision, but I'm saying also, is there not a remedy through another appeal?
Let's ask Mr. Herbert, but my impression is when the Metro Council passes this kind of ordinance related to use, that this is not necessarily something that you could come into and just, I guess you can, but.
Well, people have billboards and digital signs that are close to this or that, and across the street from a graveyard that is residentially zoned. I mean, maybe it's explicitly not appealable. I do ask the question.
So put me on the spot. Just a knee-jerk reaction would be that it seemed to me that the import of this ordinance was to establish distance requirements between these types of businesses. And while you can generally seek a variance to a setback or something like that, I mean, the main purpose of the ordinance was to establish distance requirements. I think I would probably have to view this something like if you were to ask for a variance, it would be almost tantamount to a use variance. It would be, which is not allowed, which the board doesn't have any legal authority to grant. Why? Because zoning is use and it's dictated by council, and then because the purpose of the ordinance was to establish a distance requirement, that was the very purpose of it, to allow the board then to come back and say, no, we don't think that the distance is correct. We think it ought to be this, is basically substituting your judgment for that of council. So that's my knee-jerk reaction to it. I could be wrong.
We are not a legislative body, and, that kind of logic might be bordering toward legislation.
There's I guess the overriding issue is whether or not a mistake was made, but this is not really a clerical error that was a mistake. It was a thoughtful effort on Joey's part. I mean, he put some thought into approving the permit.
Well, I mean, we've had someone say it was a verbal conversation in the hall. We've had somebody else say it was really thoughtful and written and that kind of thing. So I mean, and Joey's not here, so I don't know how deep it is, but that is concerning to me too. I mean, I'm not because I haven't been on the board and seeing Joey work. He's a pretty thorough person, so I do respect that.
If I could offer some more insight, only because I go through this, and I've had many years' experience with this, but there are other metro departments that will, and even when it's not written in an ordinance, will give you a grandfathering, a time period in which to, where you could still design or get your permit under a certain regulation that maybe has changed. So
I don't think we allow that, and our normal lawyer spoke about even pending legislation. So
I understand, but I'm saying it's happening. I'm just offering you that.
But if you feel that basically the error shouldn't have happened and his opinion was wrong, that's how you vote.
So we have to decide just to clarify, if Mr. Herbert was not wrong, then Codes was wrong before him.
But we're not determining whether Codes was wrong. We're determining whether Mr. Herbert was wrong.
But his position is that he was correcting an error. I'm not saying that to be funny. I mean, I think
that
in order for us to find that he was correct, we have to accept that what was done prior to that was incorrect.
Well, I think all sides have agreed that it was incorrect. I mean, I don't think anybody disputes that it was incorrect. I think that it was testified that the process started before the ordinance, but I don't think anyone has made claim that there was a grandfathered situation. No one has made that claim, that this was truly grandfathered. They were told by Codes that it was far enough along in the process that was okay, but no one has brought up a grandfather code to say this is what applies specifically here. They used it only in the language of what was explained to them.
I don't think there's a grandfathering provision in the code.
But we're here to determine whether the zoning administrator was either correct or incorrect. And we've heard from both sides. We've heard from the zoning administrator. That's what we get to determine. That is our charge by the Metro Charter.
With that, with what I've heard today, it's a very confusing case, a very unforgiving case, I would say. But I'm going to move that we find that the zoning administrator was not in error, and therefore we deny the appeal based on that fact. I don't have my cheat sheet in front of me, so I'm supposed to.
I'll second that.
Do I need to word that in such different, you know what I'm saying?
I would take another stab at making a little bit more
Go ahead,
detail.
you're the attorney. So.
Well, I'm not making that motion.
All right, I'm going to state the motion.
I can't believe two people aren't here. It's just...
I'm going to move that we deny the appeal based on the fact that we find that the zoning administrator is not in error on his decision. We have a second. You've heard the motion and the second. Any discussions? Call for a vote. All in favor of the motion say aye. Aye. Opposed?
Opposed.
Okay, we're 3-2. So that's no decision, right?
The item may appeal fails in the event that it does not receive 4 affirmative votes. It will remain on our docket for 30 days.
Wouldn't you have, go ahead, finish your statement, Mr. Michael, I'm sorry.
Thanks. In the event that 5 or more members are present and the appeal fails to receive 4 affirmative votes, which just happened, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within the 30 days of the public hearing shall be deemed denied by operation of law.
Mr. Chairman and staff, the last time we were here, you mentioned a situation or a procedure by which the absent members could observe the hearing on videotape.
Yes, the Channel 3 has a YouTube channel,
Okay.
so not only can we go back and look at what we did today, all of you all can go to Metro Channel 3's YouTube channel. So our procedure is the members that were absent today, they have 30 days if they want to be part of this hearing. They need to watch all hour and a half or how long we've been sitting here of that, and then the next meeting that we call, as long as it's within 30 days, they can vote, or any of us can change our vote.
Is there anything further that the appellant is required to do or may do to invoke that procedure?
What I would do is I would instruct John Michael to directly email the people not here, giving them the option and sending them the link to this particular hearing on Metro 3's YouTube channel, and giving them the option if they want to review and become part of this case, if they can.
All right. Thank you, Mr. Chairman, or Mr. Yu. You guys have got me confused about who's the chairman, but thank you.
That would be Mr. King, our vice chairman, who's in for Chris Whitson.
Thank you. Thank you.
But we'll take like a 5-minute break. Yeah. Bring up the next case so you can come up and be seated. That's the
Totally sucks for them, but I think the burden's on them to go down and do a vote for this day. And I would say the city, up to the city, probably get $600,000.
2015-72, they came to us during the break, and the opposition and the owner agreed they wanted to defer this case till next month. So we
Okay, duly noted. Let me make that note.
So did you move?
We'll have a board action. Did y'all hear me? Case number 72 wants to defer it. All in favor say aye.
Aye.
Move. Okay.
How long is it?
Till the next meeting.
When's the
They
next
think they
meeting?
got it worked out, but they'll have it, yeah.
And the next case, this isn't the next case.
No, this is number 71 here.
Yeah, but we got,
No,
68 had opposition, 68 was on consent, but had opposition.
Yeah.
Do you want to ask if there's still opposition to 68? If there's not, then we...
You're right.
Excuse me, as we reconvene with case number 72 having been continued to or deferred to the October 1st docket, that brings us back then to what had been the next numbered item, case number 2015-68 for Wendell Harmer, the appellant, property on Joe Johnston Avenue. The appellant and the individual who had been here in some form of opposition had actually had plenty of time to talk and work things out a little bit. They've reached some sort of an agreement with regard to protections on the alley so that no structures can be harmed by use of the alley. And with that, there is no opposition, and the board is actually welcome to proceed, as we had on the suggested consent agenda, to take a vote without a public hearing to approve the appeal for case number 68.
I'll move that we put that back on the consent agenda and hopefully approve that.
I'll second.
Okay, we have a motion and a second to put that back on consent agenda. All in favor say aye.
Aye.
So moved.
All right, members of the board, the next case that you'll hear is case number 2015-70. This is the property at 12th Avenue and Division Street, number 1201 Division Street, in the Gulch area. This is a request for a special exception for height in the downtown code zoning designation to construct a 38-story multifamily and mixed-use development. The photo you see here is the aerial of the unique triangular-shaped property right at the intersection of 12th and Division in the lower end of the Gulch. The zoning map clearly demonstrates it's well within the downtown district, just there at the edge of the interstate. This third rendering is part of the site plan that had been submitted by the appellant, and I'm sure that they have many other renderings for you to review today. This is just the one we had for the record in the presentation. The first pair of photographs here shows the sites going back up 12 toward the 12 South neighborhood in the upper right-hand corner there, and in the lower left-hand, this is the view back up Division. The final two photographs show the view directly across the street, and then a view of the property itself, which presently houses a commercial parking lot. With that, the appellants do have opposition present, so they will have 15 minutes to present their case. We encourage them to reserve whatever time they see fit for any rebuttal they wish to use. You've already heard from the council member with regard to this subject property, and with the packets in front of you, and more importantly, the appellants in front of you, they can begin their case.
Didn't mean to cut you off there, John Michael. Good afternoon, James Weaver Waller Lanston here on behalf of Buckingham, the applicant for a special exception under 1716-150 to allow.
Excuse me, before we get started, can I have a show of hands of people that are here in opposition to this case?
I'm not here in opposition, but I'm here to speak on the issue. I'm in opposition.
And who's here?
I'm a resident next door, so I'm learning
okay.
as well. So
and how many people are here in support of the case? Okay. So noted, yes.
Okay. Proceed, just trying to get our hands.
And we also want to make clear that the opposition, the time they have is total time.
So the opposition will get an aggregate of 15 minutes. So if there are 5 people that are speaking in opposition, the first person takes 14 minutes, the last have a minute. So you all need to kind of get together and decide who's speaking and how long.
I'm not part of the organized opposition. We allocated 2 minutes.
You would have to either be, to speak, you'd have to be in favor of it or opposed to it. We don't really have a scenario for people to speak that don't fall into one of those categories.
Strictly for a 38-story building being built in downtown Nashville, which you guys are the gatekeepers of. We're going to make this decision right here in a 15-minute presentation and 10-minute rebuttal from some folks that might be against us. And for some of those that are still trying to get educated a little bit, are sort of in semi-shock, right? They may be building the most beautiful building.
Okay, well, hang on a second, sir. This is a public meeting. We do have rules, from the council. If you feel that there has not been adequate information available either through public meetings or through your councilman or from the appellant, please bring that up in opposition. And it is not uncommon for us to call for a deferral or vote to defer a case so that more education information can be shared. Items can be negotiated possibly. But that's right, we do have rules, and it's 15 minutes and 15 minutes.
Yes, sir. Thank you.
Okay, sir, you can proceed. Sorry about that.
Well, that's all right. It seems like it's a day for unusual stuff for you guys. Again, James Weaver, Waller, Lanston, 511 Union Street, representing Buckingham with regard to this special exception request to allow a additional height on a building that we could build as a right, somewhere between 20 and 28 stories, depending on the bonuses, as a right under the downtown code. We'll have some presentations on that with our models a little later, asking for a special exception to build a 38-story structure on this site. With me today are our architects from New York City, SOM, our traffic consultants, RPM, Little John, our civil engineer here, and Stormwater Consultants, and then obviously my client, Buckingham, as opposed to the long, detailed legal argument that I was going to make to you guys after watching y'all deal with legal arguments for the last hour. I think I'm going to switch ever so slightly and just tell you a little story. When we started working on this site many months ago, we started with the premise that this site is going to be developed. It's not if it's going to be developed, it's how. And that's the question that's in front of you guys today. And so we started with a series of meetings with codes, with planning, with MDHA, with our council member at the time, talking to them about what we could build as of right on this site. And we have a model of that, and we'll show you. And asking those individuals in those organizations if they would be interested and willing with us taking a shot at looking at something different, something better, something a little more iconic, and something that might not have as much physical impact in terms of light and in terms of visuals on our neighbors. They all said, sure, take a run at it. So we did. We came back to those same individuals, codes, planning, MDHA, and our council member with a design a few months later. They tweaked it. We had a lot of discussions back and forth about it, and then we went back and we redesigned again. And we came back on our third iteration, and that third iteration is what is in front of you today. It's been in front of the MDHA Downtown Code Design Review Committee, and they've approved it and sent it to you with their recommendation. You have a letter in the file from the Planning Department. We've had extensive discussions with codes. I'll let your staff speak for themselves, and the councilman here, and the councilman can address you after our presentation and after he's heard the presentation from any opposition to it. There's been a lot written about this in the newspaper, and some of that is part of the reason that we've had some opposition to this site, and the primary reason why we had not only a public hearing, but we met with the HOAs at the Terrazzo and at the Icon, and we've got a meeting, and we're trying to set up a meeting with the HOA at 12:12, because when you read about this in the newspaper, you got the impression that we were simply going to mass this building up, and what we could build at 24 or 28, we were just going to make it much larger, adding a lot more people, a lot more traffic, a lot more impacts, when what you're going to hear from our architects, that's nowhere even close to the reality. What we're doing here is taking the same basic mass, the same number of people, the same number of cars and trips that we can put on this site this afternoon as a right, and simply putting it in a more elegant package. And that's the genesis of this whole thing. In a nutshell, that's what this is all about. And with that, I'm going to turn it over to the architects who know a whole lot more about this than I do. And we thank you guys for listening to us. Hopefully it won't be nearly as contentious as the last thing. And with that, I'll turn it over to SOM.
Hi, my name is Chris Cooper. I'm Chris Cooper with Skidmore, Owings & Merrill here from New York, and we're very excited to present this in front of you. We think that we have a very unique site here that really enables this conversation. It's unique in that this is a neighborhood that has seen a tremendous amount of development. There's opportunity to be a part of that development. It's unique in that it sits on the interstate. The majority of the frontage is actually on the interstate. We don't have direct adjacent neighbor. We are an open site that has with streets on two sides of us, so we're bound on two streets and the third side by the interstate. And it's unique also in that its shape is a triangle. And that is where we have really been trying to be creative about how to build on a triangle. So we think we're an isolated site, and because it's triangular, we have been looking at ways of manipulating that form in order to build something that's not just a simple form on the site, but something that could be more iconic. And as James pointed out, what we have done is what we're proposing is to manipulate the volume of area that we can build on this site as of right into a different shape that is actually a better proportioned building that can be a more iconic building. And because of its location on the interstate, because of its relationship as an identity piece for the Gulch, we think that it's actually a site that warrants an iconic piece. We also are trying to have it be an architecturally significant building, which I'll just touch on very quickly because I know that's not not the focus of today's hearing. But we are trying to address that it's a building that would have aesthetic value, and that would come in part from its program. So we've taken the parking base and we have put a metal screen on that that's a decorative screen that's on all sides, that we recognize that the interstate is just as much a facade as 12th and Division. And we've taken that, and we've taken the balconies that run up the sides of the building and extended that expression up the sides of the building to have one unified building, to try to make it move beyond a tower on a podium. Now, we've taken the mass, and I'll show you in a model which makes it more clear, but we've taken the kind of as-of-right mass and we've broken it into three primary pieces. One that's the scale of a podium, which relates to the podium setback requirements set forth by zoning, which is the pedestrian scale piece of the building. A second piece of the building, which relates to the scale of the adjacent buildings to the to Icon and 1212 and the Trotso. And then we have extended our tower piece, which is a thinner profile that becomes the scale of the city. So we're kind of addressing scale of city, scale of immediate context, and scale of the pedestrians with how we've masked the building. And that has come from looking at, it's a little awkward sitting with a model, but this is essentially the site, the triangular site facing the interstate with Terrazzo and Icon. And this is the as-of-right representation. And so we can build our podium, setback, and then housing above. And you see what that mass is. And initially we told ourselves we'll think of this like the Flatiron building. It's a building that has no front facade. It could be quite interesting. Triangular might actually be expressive. But when you look at that and you start playing that as a housing development and you start thinking of that as a neighbor, it's not a particularly good neighbor. And that's where we came to this notion of redistributing that bulk into a profile that's taller, granted, but thinner. And so you can see the variation, right? So we're essentially, as James pointed out, taking the same concept of a number of housing units, same number of cars, same number of people, but putting that into a different volume. And you see the level of the podium that relates to the adjacent podiums, the level of the mid-rise, which relates to the heights of the adjacent buildings, and then the tower portion, which is really about setting an identity piece, an iconic piece on the skyline of Nashville, and also planting a flag for the Gulch as a neighborhood.
I'm sorry to interrupt. Now, you said the same number of units?
That's right. So,
and not to be nitpicky, but are we talking about the same, I don't know, bedrooms or occupancy?
So the distribution, whether there's so many 1 bedrooms and 2 bedrooms and 3 bedrooms, we're not down to that fine tooth yet. And so, but in terms of volume of area of residences, we are maintaining that same volume of residences. So what the breakdown is of 1 bedrooms, 2 bedrooms, I couldn't address yet.
So what is the square feet of those two models?
It's roughly 300 square feet of rentable.
Right, 300.
Roughly. I believe it's roughly 300,000 square feet of rentable space, which is about, depending on how the unit to mix and the number of the size of the units, is roughly about 250 to 300 units.
So both of those models are exactly 300,000 square feet? With the tall one and the shorter one?
There's
Yes,
essentially.
That's right. So, I mean,
essentially,
yes, for all practical purposes,
is
yes.
one bigger than the other for square feet?
So, I would say no. So, in terms of no.
If it is, they didn't listen to what their lawyer told them to do. Let's put it that way.
I mean, I'm sorry, I'm not trying to shift. I'm just thinking, the kind of precision of this bulk to that bulk numerically, if I have exactly the nose 50 square feet difference between one and the other, I can't emphatically say.
Obviously, if it's within just a few hundred square feet.
So, Commissioner, we've been using the word materially just for that reason. This is not exact. It's not an. I mean, there are a lot of architects on the BZA, so this is not an exact science at this point. But materially, the buildings are the same mass in terms of rentable space, which equates to materially the same number of people and materially the same number of trips, and that's the reason for why we word it that way.
I have a somewhat related question. What is the maximum floor area ratio allowed for this site, and how close are you to, there's none?
There is
So there's not actually by zoning a floor area ratio. There's a number of stories defined, and that's what sets us. And that's what's unique about the way that the Nashville zoning is written, is that it's driven by number of stories. So what the result is extrusions that chop off at the top. People are maximizing. One maximizes their site development, and that's how we're saying they're marginally the same. And that's why we're asking for the variance of number of stories, but not bulk.
I think that's because you're in the downtown center.
Downtown
that
code.
you don't have a.
That's right. Correct.
So, am I still on with timing wise? I still have a few moments.
We're not taking away your time when we ask questions.
We do want to keep some on there.
Right. I just want to address one other point, which is part of, I think, what the opposition is, and I think what's an acute topic here is what are the negative attributes of going from here to here? And I think one question is it a good neighbor? Is it a good neighbor in terms of access to light and air? Right. That's presumably the caution. So that's something that I want to just address. I have shadow studies.
Have you done a light study? Is that what you're going to tell us?
Right. So we've actually done kind of technical shadow analysis. But I also just want to point to the model because I think it helps just to see. I can walk through all this, and I will. But there's also just visibly, there's a difference. And so one point is that this is the pool deck of the terrazzo. And so that's something that we've looked at very carefully because it exists today. Many people have purchased units in this with the knowledge of a pool deck in this area. And so you can see as I am north, and now you are the western sun, the mass has the potential to block and put shadow on that pool deck. And that the as of right scheme has that potential inherently built in it. And so there is an advantage of going to a reduced profile and doing it just intuitively. The nature of a skinny building is going to have less impact and it doesn't see the sun. So we now see, with this western light coming in, that there is access to the pool deck. And that's a very tangible fact. And so here, this shadow study, and I'll try to just make it very quick. This is 3 different months. The summer solstice is in the middle. So we're looking at essentially the summer months. And you can see the as of right scheme at 2 o'clock, 4 o'clock, and 6 o'clock versus the reduced profile scheme at 2 o'clock, 4 o'clock, and 6 o'clock. What's in red is the pool deck. And again, this is just to point out that there's a difference. So the bigger bulk casts a shadow onto that area, whereas the skinnier bulk intuitively casts less of a shadow onto that area.
Why were 2 o'clock, 4 o'clock, and 6 o'clock chosen instead
Just showing the range of the afternoon, let's say.
Okay. Why not 12 noon?
Because there was no impact by either building at 12 noon. So we were just showing where there's difference. Sorry. So otherwise,
the pool would receive sun at 12 noon, regardless
The residents, when we met with them, explained that the pool starts to receive sun at around 11:30 because the tower itself of their development blocks it previous to that.
I can vouch for that because I live on the west side. That's true.
So you can see, this is one specific instance, but it's an important instance. Here's the pool deck. So you are south in this case. So as the sun comes around, it shines on that. And so it's not until the afternoon hours that the sun would start casting shadow. And that's what we're trying to illustrate, is that that's where it actually becomes recognizable as an issue of the as of right mass versus a changed mass. I'll stop so there can be questions asked.
We want to obviously reserve as much time as we can. I do want to say something in particular about the shadow. As some of you know, me and Waller, worked on a number of projects downtown, and we're currently working on the Bridgestone building. And I've attended some Encore HOA meetings, and they're really unhappy about their pool being shaded. And so when we started this project, one of the things that we started talking to the architects about is that while we're looking for an iconic structure, and we obviously had to have a structure that works financially, if there's anything we can do to protect the pools of our 2 neighbors, we want to try to do that because it's an important amenity for these folks. And the as of right design, the bulk that we can build this afternoon, impacts the pools.
Mr. Weaver, why is the swimming pool such an important part and not someone's balcony or view of something else in the terrazzo or the icon?
Well,
I'll be happy to answer that. From a real estate perspective, the pool is a shared amenity. Everybody's value is determined by the amenities in the building. And frankly, what we're doing with the smaller massing affects less people's units as well. We're just focused on the pool because of its common feature.
Right. The proposal that we have in front of you is better from a view standpoint for a number of people in the terrazzo, and it's better for everybody in the terrazzo with regard to the pool deck. And again, we have certain rights that we can development rights that we can exercise here. But the idea was, let's try to do something iconic, and let's try to be good neighbors. And we've made every effort. We've had, as I said earlier, we've had a public meeting. We had about 45 people at that. We've had 2 HOA meetings where we've had about 30 at that. Obviously, there are some people here who are in opposition, but there are a whole lot of people who have been at these meetings who are not here also, and hopefully by their absence, they've heard this same presentation, and they understand that we are trying very, very hard to be good neighbors. The letter that I put in the file sets out the legal justification for this, and that we meet all the criteria of subsection 150. I won't take up y'all's time by going through the standard for special exception. We believe we meet all the criteria. We would ask you to approve this special exception. We look forward to doing this wonderful development in the downtown. And with that, Mr. Chairman, that ends our presentation. We do have our traffic engineers here, and as well as our civil engineers. If you've got questions, then we'd be happy to bring those folks back during the Q&A. Thank you.
Okay, you'll have 2 minutes and 33 seconds time for
Yes, sir.
rebuttals. We'll bring opposition can come forward now.
So during this period of time, as we said earlier, the opposition has a total of 15 minutes. So anyone that wishes to speak during this time, they have to share the 15 minutes with the people that are already up here. But you all, like I said, have 15 minutes, and then we'll hear from the other side again.
Can we just divide it equally?
That's up to you all.
I think we have.
We're going to be in longer than.
Yeah, we've got.
You'll have 2 minutes.
2 minutes.
Hi, I'm Barbara Bennett, a resident.
Please press the button.
Sorry. I'm Barbara Bennett, a resident of 1212. John McLaren is a resident of 1212. Stuart Lowry is a resident of the Icon. I don't know who this is. We have handouts. I don't know if we should give them to you now or...
So 1212 being the new condo right off of Division.
Yes, in the Gulch, yeah. We did not misunderstand at all the redesign of the building and its architecture. There were meetings. We've seen the design. We don't believe a special exception is appropriate in this case for 3 reasons. It appears to us that the Board of Zoning Appeals actually does not have jurisdiction to grant a height exception in this case that the DTC governs. 2, we don't believe that the requirements, even if it did have jurisdiction, we don't believe that the requirements are met, and we've done a separate sun and shade study that contradicts theirs. 3, we don't think it's appropriate in the Gulch, which is the subject of brand new legislation that says height exceptions shall not be granted because of the scale of the Gulch as a transition neighborhood between the DTC and a residential neighborhood. We don't believe that a 38-story building, which would be the only one ever built in the Gulch, would be allowed to be built. Should be allowed to be built and destroy the character of the Gulch, especially right there on the lot where it transitions from the Gulch into a residential neighborhood. So those are the 3 reasons that we think that this is just not an appropriate move. I'm confused because on the announcement for this case, They said that the appellant alleged that it had jurisdiction under 1740-10C, and they just said that they had jurisdiction under 1716-150. Those provisions govern special exceptions for use, special use exceptions. They don't govern the special exception on height. So I think they don't apply, and I'm really confused.
Hang on just one second. We had this very same discussion for a building downtown, I forgot what building it was. And what did we decide?
We had standing and we voted for it.
Right.
And was that appealed?
Was it appealed?
Yeah, has it
I'm
been
not
appealed?
aware that it was appealed. I'm not aware that it was. But this board does have jurisdiction. The downtown code actually references the authority to hear cases like this. Page 14 of the downtown code references variances and special exceptions. In pertinent part, it reads, additionally, variances and special exceptions to the GTC standards on height at the street and overall height shall follow the procedures of 1740 Articles 7 and 8. The DTC DRC shall provide a recommendation to the Board of Zoning Appeals on such cases. And the applicable provisions under the Metropolitan Code of Laws is 1712-060, specifically subsection F, subsection F3 and 4 are the ones at issue.
Okay, I mean, I read that, I'm not going to question what you're saying, but I read it that this is a variance. This is a special exception that is specifically for the DTC standards, of the height standards. So it would not be handled under Chapter 1740. It is a DTC standard overall height, but it's not a variance.
No, I would like to say this. I think our lawyer has already kind of ruled on this case, and so I think we're probably most likely going to agree. So I would change your argument to something else.
All right, well, I'll go on to the second argument, which is that 1712-60, which is one of the provisions relied upon that applies to the urban zoning overlay and provides that a structure may exceed maximum height based on a special exception by the BCA, has been made inapplicable to the DTC by recent legislation. Ordinance
What
number...
legislation is that?
It's ordinance BL 2015-1053. It adopts and makes currently effective a revised DTC and revises section 17.12.60 of the code to make it consistent with the DTC by removing the variance option for DTC property under that provision. And so I think, and the DTC now says that there will be no height variances, that any height variances have to be done under the DTC modification process and not under the code modification process. There was an amendment to that provision, and that provision was introduced by the council member for District 19. There's an amendment to that provision, but it doesn't seem to apply in this case. So whatever the arguments are, I don't believe there is jurisdiction to make this exception. But let's assume that there is jurisdiction to give this exception. We don't believe that the relevant requirements for the exception are met. And in particular, the exception provisions require that you look at the impact of light and air, among other things, on neighboring buildings. I don't care how really beautiful the building is. If it's 38 stories high, it needs to meet the requirements for allowing that much additional height to be added to the building. We also commissioned a sun study by Earl Swinson. Some of the results of that study are before you. Thank you.
So are you familiar with their sun study? Have they shown you their sun study?
Well, some of it. We saw some of it at the meeting.
And I'm assuming your sun study is different from their sun study.
It is.
And then why is the massing different in your study than their study?
couple of reasons. Well, first of all, we did more than them because we looked at the icon too, where there is even a larger adverse effect. They only showed you the terrazzo. There's a much larger adverse effect on the icon. But for the terrazzo, it's different because of the months chosen. Ours is July 4th, and theirs was when the sun is not as intense, which is, I think, sometime in June.
Well, they have May, June, and July.
Let me just, sorry, John McLaren here, let me real quick. The top page is the terrazzo, and the point is, as they were made in their thing, is they're trying to save the light on the terrazzo pool. This top page is, if you look at it from the short mast versus the tall mast, the difference is 1 hour. The point is, it's 1 hour difference in the sun on the pool.
Well, I mean,
that's what the page says.
Well, and I see that, but I also see that it looks like the short building in your drawing basically just chopped off the 20 stories, but that's not the model they showed as the model they can build by right. It is a triangular shaped building, and it's that back part of the triangle that causes the shadow problems in their study. So I guess this isn't an apple to apple issue at all. So I mean, you may say, well, they're going to build the skinny building anyway. They're just going to chop it off and build a smaller building.
No,
but that's not what they testified to, and that's not what's sitting down there. So I guess I'm trying to make sure when you all make a claim and they make a claim that we understand what language everybody's speaking and what we're talking about.
We simply took the front of the building on 12th Avenue and made it the width of the
Right, but your comment was just about the terrazzo's pool and the shadow, any shadow that this building, that the shorter building causes the terrazzo pool is due to the mass that is from the edge of your building toward the interstate that you don't show in your mass. I'm saying you're showing a mass that is not what they're showing in their shadow study.
And we don't know what they will build or will not build.
Right.
We don't know.
And fair enough, but you're making a point that you're assuming what they're going to build, and they told you what they can build and not build. I'm just saying, if you're going to make a point that there's an hour difference, there has to be an assumption of what's going to be built. So you're making an assumption of what's being, and I'm not trying to be argumentative. I really am trying to make sure people watching and everybody here knows. If you have a shadow study, they have a shadow study, and it's not just about saying, it's going to be dark at 4 o'clock. It's like, no, it depends on what type of building you're looking at, where it is, where the sun is. And like I said, I'm sure your shadow study is right, but I'm just saying, making a point that there is a dramatic difference in the massing of your short building than the short building that they're showing in their shadow study.
We question whether or not the difference is that large between the tall building and the shorter building. But even more important in our view is the fact that the icon is significantly shaded by a taller building,
which is your second page,
to a shorter building, and that's the second page of the study.
That section of the icon where I live is where we have our pool in the courtyard and where we enjoy the sun in that area. And so the taller building, what might spare some pool shade in the terrazzo, does take our afternoon sun shade from our pool and the courtyard area.
And we also show on the third slide how the new building would look from the 5th and the 15th floor of 1212, which is where we live. And it just shows how a taller building is just not in line with the rest of the gulch. I think that's what we wanted to show there, especially right at that transition point where the DTC is transitioning.
But does that affect your sunlight or light or sound because the building blocks away
But it affects our view. And it does affect sunlight in a way, but it affects our view mostly. And the view of the gulch and the character of the gulch is what we're going to show, what we were just pointing out.
I'm more interested now in the icon. So you're saying that this is going to shade your area. So you're talking about the 38-story?
Yeah, I'm talking about the taller, the proposed 38-story.
And what are you basing that on? Are you basing that on this Earl Simpson's?
I am basing it on the fact that I live there and I know where the sun shines through, plus the combination of this shade study.
So if they were to build a 24-story building, which they have the right to be if they get these credits, would that affect your?
The 24-story building, in my opinion, would not shade the courtyard area and our pool there. So, and now it flabbergasts me that a building with 300 residents can be built in that tiny little sliver lot. I don't know how you can get the freight trucks in there. I don't know how you can get valet, but apparently that's not up for debate today. It's just the height exception. It would amaze me that a height exception would be made when I can't even fathom how 300 units can be placed in that little lot and not block 2 lanes of traffic like many buildings do in the Gulch.
So I will tell you, I'm glad there's not a recording of me driving through some of these construction areas, because it wouldn't be pretty. It's probably what you're saying in your car too, and I am 100% appreciative of that, and I think that's something that council and codes and everybody's going to have to work on when we build new buildings. But you're right, it's not something that's really on our plate here, is what it does to sidewalks and that kind of thing during construction. But no, you're right, it's an issue
even after construction.
But I want to address your point. If you look at the second page, the top 3 slides are the shorter building, and the pool that this gentleman is talking about it's hard to tell, but this corner, it's within there. That is actually a well that goes down into the building, and you can see that the shorter building doesn't really affect that well, whereas the taller building affects that well. If you look at 2 o'clock and 3 o'clock in the afternoon, at 3 o'clock, it totally covers that well. So anybody whose light is only coming from that well is going to be totally dark. And the only light that they have coming from that well is all of the people who live along that side of the building. They live in that well area. That's their sunlight. And this tall building would absolutely block out that sunlight totally versus the shorter building.
Now, tell me the other piece that I'm having a little trouble with. I'm looking at your study on the Icon, and I'm looking at your study on the terrazzo, and I'm looking at the tall building. With the tall building there, and let's just pick, a time. They just don't seem to match up.
That's because the first one is July 4th, which is the terrazzo. And the second one is, we picked today's date, September 16th, because the sun is obviously in different positions.
Okay. Well, yeah. I see what you did. It's just confusing.
Okay, sorry.
So I have a question for our 3 architects on the board, because this is not my shadow and sun surveys are not my expertise. We have 2 conflicting surveys. So obviously we've heard testimony, different dates, different time of day. How are we supposed to make heads or tails of what both people say is it impacts it, it doesn't impact it?
Well, I think the first thing I would ask for, if this were deferred, would be, I would like to see sort of apples to apples and have, these are computer generated, so I'm going to make the assumption my clients make all the time that they can press a button and get exactly what I want. But I would like to see the 2 shadow studies presented in the same format at minimum. Theirs is in plan view, and this is in a isometric. So it would be easier to compare the shadows in the same time.
Well, yeah, maybe we just go a little bit further down the road to see if that's necessary. Because one of the things that I'd like to ask the folks that live in, I guess there's only one of you that lives in the Icon, is what are the times of the day that courtyard gets sun? Because it looks like the pool is down. Is it on the ground level, or where is it?
I live in the Icon also.
Well, you're welcome to come up here.
Nobody uses the pool.
Yeah, no, he's on.
Well, no, hang on.
But you're not. I think he raised his hand for supporting the project.
I've never seen this gentleman at the pool.
But
Yeah, let's not
I guess
mess up our time
let
with
me
his.
just ask. All right, I'm asking a question. So let me ask the question real quick. The pool is in that courtyard on the ground level. It's not up above on a parking lot or anything else. It's in the ground level.
That's correct.
So there are how many stories around each level of that pool? 5? 8. So there's 8 stories already around that pool. What is specifically the adverse effect of this extra
Well, the
20
pool
stories.
does tend to only get sun between about 11:30 and 4:30, but you're taking away half of that sun time from that pool at the ends of the season.
David, that's what I was saying. If we could look at these in plan, we could see, on the plan drawing, we can see the shadow of the Icon courtyard during those times, but we can't see what, we can see there's a shadow, but we can't see where it is on the ground, if you see what I'm saying.
But does that show the Icon, or does that just show the terrazzo, basically?
I'm sorry,
There's Icon Pool right there, the little...
But did the shadow take into effect the, okay.
I think it's the whole shadow.
Right. So I'm just saying, if we could look at them in the same view, then it would just be down to competing experts, as it were, and then it would be up to us to decide if there was a difference.
Well, and that may be part of the discussion. I mean, I think that if, I think we can ask enough questions to get a sense of what people are talking about with the shadow, and then we'll know if we have enough information for a decision.
The real big point of a special exception is its impact on light and sound. And so this is probably the most critical part. And so if we have conflicting architectural shadows and sun surveys, it would be nice to, like you said, compare apples to apples.
Well, I would like to tell you, I would like to propose that if they would do a sun shadow study with their building, and they would simply use September, today's date, with their sun shadow study, it would cover the courtyard of the Icon. That's the point.
Okay, well,
they use, May, June, and July. They have not used September the 19th or September the 17th, because that would adversely impact what you would see from the sun shadow study.
Okay, let me clarify one thing first. When the appellant was saying this, I was not writing fast enough, but you guys are from 1212 and Icon, but 1212 has not. They were trying to get a meeting with you guys.
We don't have an HOA yet. The developer has not turned the building over to us yet, and so we have no way to communicate with each other, and we don't have any organization.
So
yet.
would you be interested in a community meeting? Would that help you to be able to meet with the architects?
But they've already testified that there's no light issue with them. There's a view issue with them.
Well, it's also the character of the gulch, and it's also a legal issue. I still contend there's no jurisdiction because of this new ordinance.
But I'm simply asking, would it be beneficial, do you think, to resolving this conflict if you could actually talk to the appellant?
I don't think so. I mean, you attended the meeting.
No, but for you, I mean, you're
Right.
here, if you were to talk to the architect and the developer, and they could kind of explain the difference between the taller building and the one that they can build, is what we are trying to say is,
Yeah.
would more time help this to be resolved or bring the sides closer together?
We certainly could listen, but I don't think so, because we have a couple of legal arguments, and we have a philosophical opposition to a 38-story building, which, as I was told by the Planning Commission, because of this ordinance, would be the only 38-story building ever built in the Gulch, because this ordinance says you can't make that kind of exception to height going forward. And I don't even think you can do it now. But that to us, in terms of the character of the Gulch, the whole look and feel of the Gulch and its livability as a live, work, play environment, to have this sore thumb standing up at the beginning of the Gulch by itself just doesn't seem to us to be within the character of the Gulch.
Can we hear from the person to your right? I would love to hear what you have to say and why you're here in opposition.
Turn your mic on.
Am I losing part of my 2 minutes? Is my 2
That was arbitrarily decided. Just please
Yeah, go ahead.
take what you need.
I'll try to talk as fast as my southern accent will allow me to. I am Henry A.G. I live in Unit 1212 in Terrazzo. My unit faces directly onto this project. My concern is the shading of the swimming pool at the Terrazzo. I concur with what Mr. Scott Travis said, that the shading of the swimming pool would be a devastating economic blow to every owner in the Terrazzo. However, in trying to work with them and realizing that this parcel will be developed, I do like their plan, basically. My quibble has been that I could not get until yesterday about 4:18 the footprint, which I need you to pass that. If you just pass that. This was obtained yesterday, and so finally we have a footprint of the podium, the mid-rise tower, and the high-rise tower. And the high-rise tower has this as its southern boundary. That is critical to this shadow study. So even if I accept the shadow study that Buckingham has produced, and incidentally, I might mention that if you will notice at the very bottom, last line of their shadow study, it states that the information is voluntary and reliance on it should only be undertaken after an independent review by qualified experts. So we need a qualified expert, I think, to settle this issue, some independent thing based on their own concession.
Can I ask our architects, is that standard boilerplate language, or is that something different when you have what he just read about don't rely on this unless...
Well, him just reading that was the first time I heard that because it's too small for me to read on our copy.
I had a feeling you were missing it. I missed it for 2 weeks.
You know, as our counsel has told us before, that, we're quasi-judicial and our evidence rules are different. We take a lot more, and it is up to us to determine whether it's, quality material or not. And,
but I guess what I'm asking is that saying this is almost like a draft, and we haven't really...
I think so. I mean, it would be up to us to determine what reason would we have to think that there is something about their shadow study that is A, misleading, or B, purposely misleading. And if it comes down to this, and it comes down to one group saying our shadow study says bad, the other group says our shadow study good, then maybe we want to consider offering a standard for them to reply to, as in we want to see planned shadow studies, and we want you to use the same footprints, and here are the dates and times that we want to see, if we want to get that far into it. Not to go too far off the rails here, but two conflicting shadow studies, even if they are on the same date and time, does not necessarily mean that one is wrong. Due to the software that is being used and the mathematical equations used to calculate those sun angles, there are popular industry standard software that bugs happen, and I've seen reports in software that I use. It's like, they're not using the right sun angle because of this, and they'll correct it. So there's room for error even among two well-meaning opposing experts.
Well, and I think that we should also talk a little bit, I mean, we can, and this may be getting into the debate, but, it need to find out really what is the impact. The fact that it is an addition and it casts a shadow isn't a negating factor.
That's correct.
And, the terrazzo is casting a shadow on the icon in the picture that we're looking at right now. They were in their full rights to build what they built where they built it, but it still casts a shadow on those two-story buildings at that time of day, or the first and second floor, third and fourth floor, whatever it is, at that time of day. So I think that we really need to talk more about what the impact is on the shadow before we really get caught up in, is there a shadow at all?
But the difference is they're coming to us and asking for 14 more stories than what the code allows. And so we get to decide what the shadow is going to impact.
No, I'm not. That's true, and I'm not arguing that. I'm just saying that there is a debate whether is there a shadow or not, but there's not been any testimony other than we don't want it on our pool as to how it's going to harm somebody. So it really is, how is it going to harm somebody? And the folks at 1212 said it ain't from shadow, it's not going to harm us at all. They don't like the character and they don't like the view. The icon and the terrazzo have maybe potential pool issues, and that's what we're talking about. But we have a full study on the terrazzo on the pool during May, June, and July. Unless we want a little globe and a sun, I guess we decide what we really have to have to.
While I was back, I'm trying to answer your question, which was,
yes, please, because you all the architects, and
I think this is probably standard language they have on their title block. But I would like to ask, if I may ask, the appellants. Did SOM prepare?
We'll ask them when they're back.
Oh, I can't do that.
Can I continue?
So yes, please continue. And I had one question before you continued. So did you prepare this chart yourself, Mr. AG? And what is your background?
That was furnished to me at 4:18 yesterday by Mr. Scott Travis with Buckingham. I've been pleading for this for as long as I've known about the project. And I did finally get it. And this does satisfy me that I now know the footprint of the various structures. And so my concern is, even assuming that they're correct about the shadow study and that it will not devastate our pool, I am proposing that if you do see fit to grant this special exception today, I would request that the condition that is on the document that has been passed out be added to the approval to incorporate by reference this conceptual site overlay so that no structure can be built on this property south of the south boundary of their proposed high-rise tower, higher than the 6th floor of the terrazzo, which has our swimming pool. And that's. Now, I'm asking that be a condition if you see fit to approve.
Based on your understanding, the current rendering does that?
I know. I'm not sure that it does. There's been a lot of vagueness about this is the only thing I've had that's concrete about where the building is going to be. And so, I've seen things. The thing that was filed with you all on Monday, and I think even earlier, shows a 7-story above ground podium level, which I don't know whether it'd be above our 6th floor. You don't know the height of floors. I've tried desperately to get the height of the podium level, and I do believe that I did. You told me what that was a few minutes ago.
Who are you referring to when you say you? The lawyer? Okay.
What is the height of your proposed podium level right now?
I believe that 8 stories in the diagram.
It's 7. Here's the diagram.
Wait a minute. The image that you have, I don't think we have that. I don't think that's part of the what's been submitted.
Of Mr. Weaver's letter to you that was filed on Monday afternoon.
So once again, getting back to why you think that this is going to impact your building or your unit, I mean, what's the real issue here?
The issue is the use of the pool. If the pool does not have sun, then the value of all units in the terrazzo are depreciated instantaneously.
But they say that it does have sun. I guess maybe it has sun some months, maybe it doesn't have sun the next month. We don't know.
I'm willing to assume that they are correct with their shadow study. And assuming that that's correct, then it's based on this south boundary, being the south boundary of the high-rise tower. So I'm asking you, if you do approve this, to make the area below that south boundary an area where nothing higher than our 6th floor, which has our pool. So that'll just be a level. And I think it's very consistent with what I'm looking now for the mass comparison. The mass comparison that they filed with this shows that their podium level is approximately, it looks like a dither higher than our 6th floor and a dither higher than the 1212. But basically, I'm asking for this to become a condition of this special exception so that we can have something to bank on, that if the shadow study is correct, the pool will not be destroyed. I would like to say this, though, that this has been a very short time frame. I'm extremely impressed with what these 3 people have been able to get together during this time frame. When I got my notice on August 28th, I went to work, and it's taken a lot of time.
Why has it taken you so long to get this from them?
Well,
That's when we received it, August 28th.
But like I said, you received this 24 hours ago.
Yesterday, 4:18. Now, I did receive from Mr. Travis a preliminary drawing of this same thing on Monday afternoon. But he had drawn in some other possible changes, so I wanted a clean copy to present to you all. But this came at 4:18 yesterday. And I think this project, I'm not opposed to this project. I think this project could actually be a win-win for the Gulch. I think it could raise the economic value of every condo in the Gulch. That's my personal opinion. But it's going to take a lot of working with the HOAs at all of these different places, because I know our HOA sent us a letter last night that they're concerned about the noise level, they're concerned about the lighting. There are a lot of things that have got to be worked out. But there's some wonderful things that can come out of this, and I think having this this high-rise could actually be very beneficial to us. I can see a pleasant side to it.
Can I interrupt, because you sound like
taking
you're
a lot of our
for it
time.
and not against it.
Yes, exactly.
And this is for opposition. It's not for conditions. And
I think I
just
made a
want
full
to.
disclosure of what my position was.
Okay, well,
early on.
No,
I think he
Hang on.
has spoken on your side.
Okay.
And it doesn't count against your time, but I do, to Mr. Agee or Agee?
Agee.
Agee, I'm sorry. In this situation, when a massing is proposed and a special exception is given, we are approving something pretty specific, and we're not approving the thickness of the mullions or the color of the glass. We could, but we won't. But whatever is approved here is what will be allowed to be built, and nothing else.
And that's why I'm asking that this be approved, because you did not have this until I just gave it to you.
Yeah, and all he's saying is that if when we approve a special exception, it's plan specific, and
Yeah,
so
they don't get to come back and change the building.
If the plan changes, we're not giving approval for, if we approve this, we're not giving an approval just for any 38-story building. We're giving approval for that 38-story building, which is what you're showing. Anyway, bottom line is your concern is heard, and your concern would be incorporated if any motion was there by default. Because as you said, what was presented follows what you're asking for us to ask for.
Well, with all due respect, Mr. Taylor, I've talked with the people from Buckingham today because I was trying to get them to consent to my condition. I think it's very reasonable. If they believe this is what's going to happen, or they can move the building north. I don't have a problem with that. Anything being higher than our sixth floor, and they can't go along with that because they say they're too early in the process to nail this down. So I realize this is very fluid. I'm trying to nail down. I am willing to go along with what they say, but this is the first time you've ever had this afternoon.
Mr. Taylor, can I address the one question that you raised, and that is the impact not on the pool and the icon, but there is a well that pool sits in, and there is a bank of units across that well, and the only light that those units get is from that ceiling well. So any shadow that covers that well is going to obviously affect the light on the pool, but it's also going to affect every single unit that goes along that well that's not on division. There's units on the inside of that well, if that makes sense to you. Okay.
And I know that there's other people in the audience potentially that are in opposition. If they wish to speak, they should assert themselves right now and come forward and identify yourself and your address and which building you live in.
I would like to, though, say that you seem to ignore the fact that I talked about an ordinance that I was told by the Planning Commission is going to,
We're going to address that.
Yes, we will.
Okay.
And we're not going to let anybody that has opposition, we're not going to let this go on all afternoon, but if there's somebody that needs to speak, and we can suspend our rules, and again, when we ask questions, we're not using your time. So don't feel like that we're going to snuff anybody out. We want to hear what people have to say.
Okay.
Great,
stay
thank you
on point.
all. My name is David Schaefer. I'm a resident of the Terrazzo condominiums. And as I had mentioned earlier, I was probably here more to gather information, so I apologize for that. The folks that are doing the building have made efforts to get in touch with everybody. It's just in a 2.5-week time frame. That's pretty, at least in my point of view, pretty short when you have folks that are, like all of us, we have, day jobs as well. So just a general comment there why I got a little excited earlier. In listening to these comments, I would say I probably sit exactly where Mr. Agee does. Notwithstanding our friends at the Terrazzo and the 1212 and their point, Icon and 1212 and their point of view relative to the sunlight, I can't really speak to that. But in terms of the building itself, I think my point of view is very consistent with Mr. Agee's in the sense of my objection would be to the back of that building where the pool is, and that the commission take a hard look at that if you are actually truly approving this building as they're presenting it. To Mr. Agee's point of view, if there's not enough detail to approve, how can you approve it? But I think they can design it. I think they're working very hard to do that to accommodate us. I can't speak for the Icon, but by lowering that back half a little bit, our pool is not going to be impacted that bad. And I respect the development rights that folks have. When I bought there, I knew people could build across the street. So it'd be unfair of me to say otherwise, right? I still, like this gentleman, I don't know how the hell they're going to put it in there, but I'd have a Chick-fil-A, but it is what it is. So that's my point of view, and so hopefully that's helpful. And I thought, Mr. Agee, I'd like to thank you for all the hard work you've done.
Thank you.
Thank you, folks, for letting me speak.
Any question? Wait a minute. Question.
I'm going to ask you, as I said, do you think there's any benefit to having further meetings with the developer and their team?
Mr. Harper, what's interesting to me is that there's not, that Mr. Agee is the only guy sitting up here from the Terrazzo, right? And there's one person from the Icon and one or two people from, it's really amazing. I would thought there would have been 200 people here. So whether we need more time.
There's someone in the back, a couple people in the back of the room.
Good, we'll charge. Okay, so I would say, at least my point of view is we've had 2.5 or 3 weeks from the first time I saw something on this. Is that enough time? It's hard for me to say. I've been trying to digest the information as quick as I've had. I've missed the meetings with these folks.
So you didn't go to the meetings?
No, sorry, I was out of town.
Okay.
I just physically wasn't here.
So what he's asking is, would more time
More time would be, I like what Mr. Agee said. More time would be helpful if we could spend time, this group, with the developers to get something that everybody could agree to. If that's part of more time, that's fine. If it's this information again, I'm fine. I get it. I understand what's going on. I would not be approving the 38-story building if the back of that building wasn't giving us some help on our pool, notwithstanding our neighbors. Did that make sense?
Yes, it did.
Yeah, sorry. I'm not. Mr. Harper, did I answer your question? By the way, I live on the 8th floor overlooking the pool. I see some interesting things out there, but I do get the sun right there on the west side, so I've kind of live it day by day.
Can we get...
Go ahead, Deb, sorry.
I was just going to say, to address the lady's question about the standing, you said you had comments, and I don't want that to be ignored. It was very nice to bring it to us, but we're not the ones to respond. Our attorney is the one to respond.
Well, we can respond, but we're going to ask our attorney.
You can hear it while we hear it. Not to be disrespectful, but I'm just saying, we are given an agenda that says we have authority. The city believes we have authority. And so if you challenge that, you raise it to us, but we're going to defer. So that, not ignoring you, but we're going to turn it.
And that's proper because I don't take questions from the applicant or the opposition. I take questions from the board. So that's proper for you to do that. I did look at the ordinance that was referenced, 2015-1053, and it does remove the authority to grant a special exception for height as it relates to 1712-060E 1, 2, 3, and 4. However, it specifically addresses the fact that any application that was pending before the passage of this ordinance is to remain under review of the Board of Zoning Appeals under the very section that I just cited, 1712-060F. I have talked with the staff and confirmed that this application was in fact pending. So you retain your jurisdiction.
So what you're saying is there's a new bill related to special exceptions that affects this area, and if they were just operating on their new bill, this might not be allowed, but they're still, since they applied, they duly applied, and they're on the agenda, and we noticed it, we can hear it.
That's correct.
And ma'am,
I read that, though, I read that as saying, all applications for special exceptions proposing additional height within the DTC district that were filed with the Board of Zoning Appeals prior to the date of this ordinance becoming effective, I agree it includes this, shall continue to be processed as special exceptions rather than variances under the DTC. And the DTC specifically says that special exceptions should be processed as a modification under the DTC, and it provides a different process for processing.
I have no different opinion from the one I've just given.
So
that gets back to the argument that we had with the hotel downtown. Who remembered that?
Agreed. That's the same argument.
And we reached a decision, and our operating procedure will still follow it until someone tells us, and by someone I mean the Chancery Court, tells us different.
Okay. Well, the second point, though, with respect to that ordinance, is that it makes clear that height restrictions in the Gulch are very important. Very important. And they should not be ignored easily, because going forward, there will be no other buildings that will be 38 stories tall.
And by us disagreeing with your jurisdiction argument does not mean we do not still take that into consideration and take it very seriously, just as the shadows and everything else.
In the words of the architects, that it's in building something better, something a little more iconic, and it's a unique site, and they want something more iconic. I feel the Gulch is already iconic. I live in the icon. I believe this negatively impacts the rest of our values and changes the site of the Gulch, and not just the sunlight. So it's more than just, the legalese argument. We feel like this exception is not needed.
And we consider all of that. And we might spend more time on one issue. That doesn't mean we're not considering others. Was there anybody else that wanted to speak in opposition?
Thank you for your time.
Yeah, thank you very much. I really appreciate it.
Thank you.
Anyone else want to speak in opposition? You have 15 seconds left. Okay, Helen, come back up.
Thank you, sir. No, it's all right. I think that's yours.
I believe there was something about a Chick-fil-A. If you want to address that first.
Well, now, I really would like for you to talk about the shadow, the competing shadow study. So, and specifically, what do you see the differences? Why did you choose the months that you chose? And do you have a more comprehensive study that is more calendar year?
So if we can treat the sun study as a question, so we're not doing that. So let me take two seconds, and I want to talk about community meetings. And that there'll, quote, never be another 38-story tall building under the downtown code in the Gulch. Just quickly, we had a community meeting that was noticed up pursuant to your rules, that was held at the convention center. We had about 40 people at that meeting, including one of the gentlemen who spoke against the project. And we've had very well-attended meetings at both the Icon and at the Terrazzo. And as was correctly stated, there's not a HOA yet at 1212, although I will admit that 1212's a bit removed from our site. I trust that you guys have a map and know where it is. So we felt it much more important and much more of a priority to have our meetings with the Icon and with the Terrazzo folks, and that's in fact what we did. And we had very well attended meetings, a lot of give and take. And you've seen the people today. I think they noted how many people showed up in opposition, being a small number. And I don't put that. I count that as because we did our work, because we did what we're supposed to do. It's not our first rodeo. We know how to do these community meetings. You have to do community meetings. You come in here without doing community meetings, and you guys make us defer. So we did what we did. We've done everything we thought we could do with regard to having those meetings, reaching out to our neighbors. This is just the beginning of the process, as the architects know. What we're asking for is an approval on the building envelope. Then we've got months and months and months of design to do after that, and then we've got a very long, very detailed meeting in front of the MDH FHA Design Review Committee, where all of these issues that have been brought up here today will be debated in minute detail.
So, Mr. Weaver, why did it take so long to get this plan to the person who got it 24 hours in? Yes.
Well, we've been providing documents as those documents have been produced. I think we thought
But
we
are you
gave Mr.
disputing
H.
that this wasn't given just 24 hours a day ago?
No, I'm sure he just got it. He's been with all our meetings. He doesn't oppose our project. So we wouldn't be in a habit of withholding stuff from anybody, much less somebody that's supportive of the project. We're trying to figure out what it is exactly he was wanting and getting him the document that he needed.
But according to his testimony, thinks it's what he wanted, but he's not 100% sure. And I guess why I'm asking this is this whole process, there are other people that might want or need information, and 24 hours before our meeting is not a very timely way to provide people information.
So I provided the drawing, and it was specifically to address a request that Mr. Agee had asked for, and that was, can you take your building outline and draw it on the parking lot so I can look out of my unit and see what number space that building's going to block. And that was an unusual request, and it took some time with the travel and the meetings we were having for me to coordinate that. I delivered a raw version of this on Monday, and then I gave him the clean copy yesterday. I'm sorry, maybe I delivered. So it was an unusual request. It took some time to coordinate, and it was.
I think that's a reasonable answer, and I think I can't speak for Mr. Young, but I think the essence is we just want to make sure that no one's being sandbagged, and it sounds like you're trying to provide information as it's requested.
Absolutely.
And my response, and to the extent my face got red, it's because we have done. I feel like that my client has gone above and beyond the call in terms of the outreach to the community, meeting with the HOAs, having the public meeting. We've done a lot, and we will continue to do a lot because that's what good neighbors do. But what we're in here today to try to do is to get an envelope, to get an idea what our envelope is. And our envelope is either the tall, skinny one or the other one. That's our choice. And so that we can start the process, because we've got a lot of work to do, and a lot of things that have to be done to take this from today to fruition. And we need to know what we're designing. So if we could,
Answer that question.
we want to talk. We've got answers to all the questions, I think, with regard to the dueling shadow studies. And so with
Can I
that,
ask a fast question of our Metro? Are they required to have a community meeting with 1212 because I think they're more than 300 or 600 feet away from this property?
I understand from staff that yes, it is a special exception, so they are required to have a community meeting.
Even though they're further distance?
no, the community meeting is driven by a distance 600. I think it's 600 feet.
It used to be 300. I think we're voting.
It's actually 300 as of today. You'll be voting on expanding that to 600 later this afternoon.
So what we
But
did.
isn't 1212 further away?
It is. So we mailed to the people who we had to mail to meet the ordinance requirement. And then we held these community meetings with these HOAs in addition to that, not in lieu of that, because we thought it was the right thing to do. And so that's again, we've tried to go.
I wasn't asking you to defend that.
I know, but I'm in a defense mode all of a sudden, so I'm sorry.
That's okay. I just thought you might want to reserve more time.
Before we get too far away, David, did you had a question? Did he address it?
My question was about the shadow. I would like to ask what's the extent of the shadow study that you did?
Sure.
You showed us a condensed version. Do you have a more expanded version that might address some of the issues that were raised by the opposition?
Sure. I would like to address that. So the caveat at the bottom of the page is put on by the developer, by our client, which is great. It protects all of us. But I'm telling you that as a professional, as a firm, as SOM, we produce these shadow studies. These are not produced by the client. They're produced by us as a professional firm. And so we stand by those shadow studies as being legitimate and accurate. And it's something that we do very commonly. And in many cities, there's actually quantification that has to happen in terms of how much shadow is being added. So additional shadow that's coming onto a site beyond the context that is existing, and the ordinances are written around that. So we're very particular about these shadow studies. We chose the summer months because we thought that made sense. So we took May, June, and July. We have
It made sense because of what?
in terms of when people were using the pools. So we chose the extreme condition, which is the solstice, and then the months on the shoulder months on side of that. And what this illustrates is that there's no question that there's no projection of shadow into the well of the pool of the icon. And so we hadn't been highlighting that because it wasn't even remotely an issue. So in the months that the sun is lower, and I guess we're pointing out that today is September, so the sun is lower.
Which the high today is about 80 degrees, so it's cool
So it could
weather
be-
still.
right. So then the question is, as the sun gets lower, then are we adding shadow beyond what the building is shading itself? And that's what's in question. And so today, what you can't see in the images that they're producing is that, because it's an axon, is whether or not the as of right scheme would be doing it, or whether or not the building itself would be casting a shadow because it's a well on the pool. And so we're saying as the lower the sun is, then the building itself casts shadow. So if what you're asking for is for us to produce the comparison today versus these months, that's absolutely doable. But what we're trying to suggest is that the well condition when the sun is lower already casts its own shadow. So it's not a matter of a building across the street adding or subtracting from that.
Well, a question to our architects again. He's basically saying that would be there no matter what.
Well, I think what he's saying is that it can be shown definitively whether the building, either scheme would be adding shadow that is not there now under any given circumstances that we choose to ask.
Even in the month of September?
Well, he's saying it is something that can be shown. I don't think you're testifying that if you looked at the model right now that it would be absolutely one way or the other, but you could determine that information in the same way you've determined these.
That's absolutely right. I don't have that in front of me to prove to you.
But it is a knowable quantity if that is what we're asking.
I thought you actually said that there's a well there now and that's already casting a shadow on the pool.
Right. So what I'm saying is that so that we're not. The implication is that we're not adding, but I don't have the material here to prove that and to say this is the case. But what I am telling you is that because it is in a well, the sun is lower, so the shadow is there already, and it's not a matter of adding or not adding.
And the pool is 6 feet, or I'm sorry, 6 stories below.
I think it was stated 8 stories. Or was it
8 stories below the well.
Well, and
so the pool is here.
Right.
And that's about 8 stories?
So Mr. Ewing, again, I'm not trying to state anyone's position, I'm just trying to clarify the technical issue. Even looking at the information that is there, if you extrapolate the shadows that are there, just as the sun goes lower and increases the shadow on a new building's mass, it is also going to increase the shadow of the existing mass. Therefore, the courtyard will be darker and it will be proportionately longer. So if you get X amount of shadow from this building, all the shadows in all the buildings are going to grow the same.
You can right to that point. So your point is that as this shadow grows and eventually spills into that shadow will have grown, and you can see that here technically. Is that clear? Is that in line with what you're saying?
Does everybody understand? Have we beat this horse enough? I don't want to. I'm not trying to talk down anyone. I'm just want to make sure you understand and that I'm answering your question.
I think we have found that. Well, no, it's not delivery.
I think what he said was basically he didn't have the information to the material that I asked for.
He does not have it right now, but it can be had. Yes.
Do you have additional comments as part of your closing?
I'd ask you for approval. Thank you.
And do you all have anything else to add? Okay, so at the beginning of this meeting, we heard from the newly elected council person, and I think he would like to come and kind of wrap this up and give us his opinion on what has happened today and his opinion on this project.
Sure. So Yeah, oh, thank you. Now I see the speak button. I think what's clear from both the proposing team and from the folks who were here expressing concerns about it is this is a conversation about height. I think it's connected to broader conversations about growth, including how we build in terms of preserving right-of-ways during construction and the impacts of new construction on streetscapes, traffic, and commerce. But it's really about height. You all received materials a few days ago indicating I was generally supportive of the project as proposed. And I think having heard from residents who support it and oppose it, having followed its trajectory in front of the MDHA Design Review Board and Metro Planning staff who've been deeply involved in the creation and maintenance of the downtown code, which covers the Gulch, and having reviewed the materials from both the project team and opponents, I would say that my support is still generally intact. But to your point, Mr. Ewing, I'm fully aware that my voice today is just that. It's not a vote. And my general opinion of the project, I think, pales in comparison to the work we see you all doing today and the important role that you all as commissioners have using your experience to gauge the magnitude of both the project and the concerns about it, which are real. I'm new to this, as you've identified. This is a large project, and I'm not here to participate in a fight, but to try to push a process to its best outcome, which I hope will be possible even if I express a position that causes disagreement. So concerns, well, actually, let me go to things that excite me about the project overall. World-class architecture that serves as both, I think, a beacon for and a gateway to the Gulch, likely LEED eligibility, reinforcing the Gulch as a LEED neighborhood in Nashville, and improved pedestrian and streetscape experiences. Now, the fact of the matter is most of these things would be possible without the additional height, which leaves the question of why taller is better. To me, the answers here should be to be a better neighbor. I think we've heard some suggestions of how that's possible. The other is to create a better overall project for the city, the users of the building, and the neighborhood. You know, as I've talked to various both supporters and opponents of this who are Gulch residents, I think the conclusion is that everybody that is looking at the possibilities for this site want the best possible project. And I think what my personal opinion is and what I've heard more of is that this project delivers on that. Now, the flip side of that is that concerns include whether the height alone adversely impacts other properties in the area. We've heard a lot of discussion about that today. And then whether granting a special exception for height begins a process of dismantling the meaning of the downtown code and thus ultimately damaging the character of the Gulch as a neighborhood. You know, regarding the former concern, I really do have to entrust to anybody looking at this, particularly those of you voting on it, that you're evaluating all the presented materials thoroughly. I have looked at it, talked to residents, and I feel that height alone is not going to create undue adversity that is not there from the potential massing. Regarding the latter, in terms of character, I think this specific piece of land at the top of the Gulch on an unusual sliver next to the interstate actually suggests that an exception is reasonable. And I think, you know, further, the mechanism by which this exception would be granted will be last of breed per recent changes by ordinance to the downtown code. So as someone who seriously considered purchasing a unit in the Terrazzo before I moved to where I am in Salem Town, and as someone who represents the interests of Gulch residents, I too take seriously the character of the Gulch as well as the downtown code as a planning document. So I'm not standing here pretending I claim to have the right answer. I claim to have an opinion, and that is that I think that this project, as presented for design purposes and quality of project, might actually be a superior project if the exception is granted. So with that, I say thanks to all of you for your service. I look forward to the deliberation decision and working toward the best possible outcome.
Thank you.
Well, now.
That's the public hearing?
You have anything further to add? Do you have like 2 minutes left?
No, I think they have like 50 seconds. Okay. Close the public hearing.
Okay, we'll close the public hearing and we'll move into deliberation discussion.
So to me, what this comes down to is whether, and what we're charged with under special exceptions, does this building affect the light and the sound of the neighboring properties? And given that we have two competing and differently done shadow studies on different days, I don't feel that I can kind of tell that. So I would be wanting to get more information and hoping maybe even the council person could meet with the groups. And I think they're very close on getting something that would be really good for the neighborhood. And, you know, it's not going to please everyone clearly, but I think they can get there.
I agree.
The Egyptians and the Mayans were able to very accurately forecast shadows and things thousands of years ago, and I think we can get there here as well. So,
Yeah, and the only thing that I would want us to talk through a little bit more is specifically what it is that we would like, because you know, we see the sun at its highest, and we know, you know, maybe we need a lesson in shadow, and it sounds like we may not be hearing a lot of these again, but we may, and somebody's going to be, you know, hearing them, so we might as well educate everybody on how to think about it. But you know, I agree with the council person and the planning commission that it's a stunning project, and it's something that I think is will be iconic, and yet I am also very sensitive to the charge that we have. I do think we have a lot of information, and in either of the shadow studies, I haven't seen anything that would say to me, this clearly is detrimental in a way that would make me say, okay, vote no. But if we need, you know, you like more information, you agree.
No, I think it's a reasonable request. And I'm not even talking about months and months. I mean, we could set it for the next meeting.
Absolutely, and I wasn't suggesting it was unreasonable by any stretch. In fact, I was just saying there are two members that feel that strong concern. My only request is there, what would you like to see? Again, knowing that we're not experts on shadow studies, but what is it that you would like to see that would help?
I think the shadow studies in the month of September, or even this date today, because clearly today is a pool day. If many of you who live in the Gulch weren't sitting in front of us, maybe you'd be by the pool of the Icon and the Terrazzo. And the fact that the study did May, June, and July and did not do August and September, to me is incomplete. And so, you know, I want to see the month that the pool, you know, I'm not asking for December. You can make the argument, well, who uses the pool in December? But it's 80 degrees outside today. It's cool weather.
I propose that we ask for 3 or 4 specific dates that we want to see. Mm-hmm. And if the opposition would like to go back and do those same dates, they can submit them as well, and then we can decide for ourselves.
Well, I think the opposition already has today.
Well, I'm just saying, and I say we specify how they're presented, so they be presented.
How about if we pick mid, you know, maybe we can ask, we do have a shadow study expert, someone who, or at least who has access, and maybe that's, yeah, I think clearly we want to see the full season of pool weather, May through September, and we can pick mid-month if that makes the most sense. Does mid-month make the most sense? The 15th of May, June, July, August, and September, and the time frames I think are fair. But I also have a lot of respect for the appellant's approach to shadow study in terms of showing the shadow that currently exists, but then also the additional shadow, and it feels like it's.
I don't dispute that, but today is, like I said, it's a pool day, and we don't. And the opposition is saying, but then again, you said the building itself.
I think that by setting very basic criteria, let's say 4 dates. Let's say June 15th, July 15th, August 15th, September 15th would cover, that also covers the spring because the sun's seasons are symmetrical. So, and then we could have 1 or 2 times on each of those days, and then whoever wants to show us information on those days is welcome to.
And I'm not sure if the other board members would be agreeable to this, and I didn't necessarily agree with what some of the people from 1212 said about just a big building just in the Gulch. But if it affects their light or their view doesn't count, if it affects light, sound, all the things that are in the special exception. But what I'm saying is, I think it would be helpful if the council person had another meeting for the people that didn't come to the other meeting, and for maybe people of 1212 if they do have an argument related to what we're ruling on.
Well, and that, if we're going to ask them to do another meeting, we should, maybe the next meeting is too soon. We have to balance that with.
But what do you all think about another meeting?
I don't think it's necessary at all. I think they met with the immediate neighbors. I think we had 2 people from the, and again, with very due respect to the folks that came from 1212, I respected, I didn't agree with the arguments necessarily, but I respected their opinion and their right to come here and talk. But I don't, they're further away. They had, they came very opposed to it and knew what our criteria was and didn't address any of the light and sound. It was standing, and they had other issues and view. So I think that opportunity has clearly been given, and I don't know that there's.
But if our chairman were here, Chris Whitson, former council person, I think he'd be saying, can't you all get together?
And maybe I misread, but when I was asking people, they didn't seem to be that interested.
One of the persons I think that you asked it to, basically it sounded like he was basically not in opposition at the end of the day.
Well, and I guess all I'm saying is that I think that the appellant has shown a willingness to talk and to give information, and there's plenty of opportunity for everybody to do it rather than require a formal meeting. So if they come back in 2 weeks and say, did you have your meeting? No, well, we got to put it off. I just think, now if they came and said, hey, we've asked for this for 3 days and we never got it, and we made 10 phone calls, and there's some evidence of not being responsive, but then I think
let me ask the council person just one question related to that, and I will defer to you as far as if you think that would be helpful or not. But would a formal meeting be helpful to get everyone together? I know there have been already a couple, and they've been to some of these units. Not to put you on the spot, brand new council person.
I think more instructive is going to be, those meetings would be useful, I think, with the apples to apples, or with a, calendar year of light studies or something like that. Something that helps illuminate the questions about the shading.
I made it through this whole meeting without making that pun. And you come up here and just.
And
I was put on the spot.
The purpose of this is to get you all closer together. We're not trying to,
I say, I would appreciate it just from the perspective of, understanding more. But I think when it comes down to what is the impact of the exception going to be, it's ultimately going to be, I think, even more than sound, light. And that's, if we get any clarity on that from a meeting, then great. I don't necessarily, from what we have heard today, I'm not convinced that meeting just for the sake of meeting moves it forward.
But I guess that's why I'm asking you as a representative from that district, if you did would anything good become of that, and would you be willing to do that? And
I'd be willing to, and my good that I would seek from it would be clarity around what the lighting impact would be.
So once we had this kind of apples to apples survey, and I'm not talking about another 2 or 3 meetings, just one somewhere that, and the people that were out of town or didn't get to come or from another unit.
Well, and I mean, when we get to apples, I don't know, if we look at the architectural rendering we saw from opposition today, I don't know how reasonable it is to say to them, okay, you as concerned citizens go produce a re-rendering.
I was gonna make a proposal to that, and if everybody likes it, later on, it can turn into a motion. I don't want, this is a big issue, but again, it isn't the only thing that we are considering, which is something we've spent the vast majority of time on. And my proposal would sound, my proposal would be this, and the a motion would sound a lot like it. If the appellant, by a set date, certain, let's say by Monday or Tuesday, could provide a drawing, two drawings similar to this, the by rights and the proposed, and there are three basic elevations that one could derive the mass from if they had a footprint. And I'm saying this as a proposal. I'm not making it an order by any means, because there is some proprietary information here. But if they could say, here are the footprints, and this has a lot of information on it for people who would do the shadow study. This piece of the pie is this tall, this piece of the pie is that tall. And from that, a shadow study could be with the information the opposition obviously already has. That way they would both have the two correct building masses. And if the appellant is willing to provide that, then I would say within another short period of time, say another 2 weeks, since the opposition is having to hire someone to do this outside, certainly within a month, we could have apples to apples.
I would almost, this sounded, and I appreciate what you're trying to do, and it sounded complicated. And I mean, is there some reason that we wouldn't trust the appellant's shadow study?
Because it does not consider today, and we had testimony. I'm making an assumption that this is deferred, and we have 5 dates. And we could pick some of the dates that they used.
Well, that's what mid-month, June, July, August, September is what David Harper said. But we're getting more complicated to say, well, let's get the massing to have someone compete. And I think what we're needing is just information. We're saying we need 2 more months.
The burden is on the applicant to prove that it doesn't directly impact the neighboring properties.
I get that, but what he's saying is that we need to provide the opportunity for opposition to compete with a shadow study, and I'm saying I think that's getting too complicated. Let's just ask the appellant to provide the extra data points that we want for the whole season, unless there's some evidence here, and the opposition didn't.
I don't think it's as complicated as you're sounding. I mean, and they could refuse to, and the opposition might not want to produce another.
Right.
But I'm just saying
but we're giving them the option.
The opposition didn't dispute the shadow study. The opposition said it was a different time of day, and it didn't show the icon right. Well, they heard that, and if they come back in 2 weeks and I guess this is an expensive meeting for everybody to attend. People are taking their time off work, the opposition, and so I think that we need to have something that is reasonable, that lets people get this back in 2 weeks or at our next meeting, that answers the questions that we have and addresses those issues, so that we're not talking, so that we don't really miss the opportunity for these folks to build this type of building if that's what they want.
But for the reason it is so big and so iconic, I think that we need to make sure that we have done our due diligence. This would be one of the larger buildings built in Nashville, Tennessee in a while, particularly residential buildings. And it's not like we're just approving some 3-story house in Green Hills. So that's why I think that we need to do more due diligence.
I mean, I'm not, and I haven't, and I'm not going to argue against due diligence. I'm just saying that unless you disagree that if you think that we need to have the opportunity for competing shadow studies, well, fine.
I think
but
we have to
I'm
have
not
that opportunity.
But
I think that they've already produced this, so they're interested in it, and they should be given the opportunity.
And I'm not saying that there should be competing. I'm just saying if that basic information can be made available to the opposition, they can choose to do it.
They just said if they can see it in advance, I think that's satisfactory.
Okay.
So that So then that may answer it, so that if they see it in advance, say.
They might agree with it.
Okay, so
A week
when's our
in advance and.
When's our
then-
next meeting? Is it the second Thursday?
Yeah, and I don't want to deny them the opportunity but that seems fair, but it does seem almost burdensome. If they saw it and said, I don't agree, let's get our own and see if they concur, fair enough. But if they look at it and say, fine, there's no reason to go out and have two people spend money and time and delay this thing more.
That's fine with me.
I've not said a lot, but I've listened a lot. If you look at those two models right there, what they can build right now, whatever's built then is going to impact that neighborhood, obviously. Nashville is not the same city it was 10 years ago, 15 years ago. It's not going to be the same city in 10 years from now. Nashville is exploding. I've got to commend this architect and this design. To me, that thin thing seems like it's a lot less impactful on the entire neighborhood than this mass over here. Wind, air, light, all of it is less impacted by adding a few floors to this tower. I commend the architect, who also was the architect on what used to be the National Life Tower up there back in the 60s, and I worked on that building as a grunt, pardon me. So I'm honored that the city now has another opportunity to do another iconic building. I support the project myself, like it is. I think it's a vast exercise in beauty, concern, and something less impactful than the mass that they can put down there. So I would, and I know how hard and what all is involved in putting the whole thing together. They got a lot of work to do. I say the sooner we give these people an answer and let them get started, the sooner this city can reap the benefits of this project. So that's where I stand. I support it.
I agree.
I think the job of our board is to follow the special exceptions, and I cannot answer whether this impacts light on the other building based on what we have been presented today. We've asked for additional sun studies for today, which is reasonable given that it's 80 degrees outside and people use pools. So
I agree with you. Were you going to make a motion?
Well, I'm prepared to make a motion. Then I move that we defer this to the next meeting and that we ask, or I'm sorry, I move that we defer this case to the next scheduled meeting and that the appellant provide shadow studies for the right to build and the proposed massing and no building, as in what's not there, for the following dates: June 15th, July 15th, August 15th, September 15th, and the times of days for each of those days be noon, 2 p.m., 4 p.m.
And the only thing I would add to that is we will put them at the first item on the agenda.
Yes, and yes, I'll accept it. And I would ask that and I'll need to make sure that it is possible that they be provided 1 week prior to that meeting date to the office so that the opposition can get it.
So provide to the codes office so the opposition can get it from the codes office.
Yes, and yes.
I think that's an acceptable motion, except why would you require a shadow study on if no building were there?
Just to show. It's arguable that that is moved, but just say, look, here's the shadows you're going to get if there's no building.
One of their arguments was basically it would be shadow whether we have a building or not. That's what the architect said.
He's got the computer. You just got to push the button.
That given where the pool is, that there's just going to be natural shadow.
Mr. Chairman, I know you're in deliberations, and I know I'm not supposed to do this, but we need a little more clarification What exactly are you looking, impact on?
I'm sorry, the shadow, I'm speaking directly about the shadow studies and plan on delineation.
On the Icon pool area?
Just as you have presented.
Just like that, the
Just
Icon and Terrazzo.
To clarify, those dates and times and those conditions that I just said, in the same scope that is presented today on that board.
And by scope, you mean vertical, horizontal, the same horizontal presentation?
Plan view?
Yes, plan view. Just, no more buildings, no less buildings, but what we're seeing today, but on those specific dates, those specific times.
Thank you. I apologize. I know I'm not supposed to speak.
2 more columns and 1 more time.
Something like that. Is there a second?
I'll second.
Okay, you've heard the motion. All in favor, say aye.
Aye.
That was an aye.
Okay, the motion passed, so it'll be the first next meeting.
And you'll be, the meeting starts at 1 o'clock, so you'll be the first item on the agenda.
What's the date?
It's October 1st?
October 1st is the next meeting. The 1-week window preceding that meeting is September the 24th. Office closes at 4 p.m. Should be available to the public probably by the next Friday morning at 8 a.m., September the 25th.
Is that doable?
All right.
And Mr. Vice Chairman, I would respectfully recommend a break at this juncture before we head into the next case.
Okay, sir, 5 minutes.
And we're going to lose David.
I've got to go. Yeah, I didn't, I was like misunderstood. No. Oh, I know, but I was like.
Mr. Chairman, next is case number 71, which involves property at 2605 Morgan Mead Drive up in the, Madison area. Thomas Sappel is the appellant and owner of the property located there. The request is one for a continuation of non-conforming use in an RS10 district. The use in question is a duplex use that had been damaged in the May 2010 flood. It's been referred to the board as an item D case for the continuation of non-conforming use. I'll also draw your attention to the Metro Code 17.40.650B2, which is a section that deals with the extended time that had been made available to properties damaged in the May 2010 flood, namely a 60-month window. The first picture that we've shown here is the aerial, carefully outlining the property in question at Morgan Mead, there near the intersection with McGinnis Drive.
Need to get the appellant come to the table, I guess. So, yeah.
And as he makes his way and takes his seat, we'll point to the zoning map to show the RS10 zoning district that plainly applies here. The photos demonstrate the face of the property and obviously the zoning appeal hearing sign as well, and a view straight across the street from the property. Then up and down each end of Morgan Mead Street from the subject property. With that, I believe there is no opposition present on this case. The appellant will have 10 minutes to present his case.
Okay. So give us, Mr. Herbert, give us a little history. We obviously had a devastating flood in the city of Nashville in May 2010, and normally you have a certain amount of time to continue a non-conforming use. Tell us what happened and why this is outside of that.
Well, typically if you've got a duplex within an RS district, it's legally non-conforming. There's a code provision that allows you 24 months to tear the duplex down, or if it's damaged or destroyed, and come back and build another duplex there. In this case, for properties that were damaged by the 2010 flood, the council extended that time to 60 months. So it's my understanding that this case did not come in and get its building permit within that 60-month period. So my understanding is that they're asking for the board to grant him an extension so that he can, even though it's beyond 60 months, so he can go ahead and make whatever renovations are necessary.
Okay, let's kind of quickly, so why didn't it get done within?
Well, hang on just a second, Mr. Chairman. I just want to make sure our legal counsel answers this one question. What basis are we, what do we have to find to allow this continuation, or are we just We have to have a reason to continue, correct?
Respectfully, I'm actually locating that in the code now. If I could have a few moments to look at that while you all go forward.
I'm sorry, Ms. Sheehan, I didn't
that
mean
would
to-
be very, very helpful.
Okay.
Okay, thank you.
So the question is, why, please introduce yourself.
Yeah, my name's Tom Seffel, and I own that building. I bought it in 2008, and we had renovated one side, and we're in the process of renovating the second side when the May flood happened. So I had tenants in there.
How much damage was done from a dollar standpoint and a water standpoint?
The contractor, the water was 3.5 feet deep in there. And my tenants actually had to evacuate in a boat and get out of there, but they got out okay. The contractor estimate was $66,000 of damage to fix it. I paid $109 for the structure in 2008. And when I went to get the building permit to fix it, so we had what they called significant damage. So FEMA requires if you have significant damage to raise the structure up out of the floodplain. And you can see from, I don't know where the one picture there, you can see how tall the crawl space is now. So I actually had 3 buildings that flooded in that May flood. This was just one of them. And I had some professional house movers come, and we lifted the structure up and built almost 4 feet of additional crawl space underneath of it.
I'm sorry, when was that you did that?
We did that, let's see, well, the flood was May. We probably raised that July 2010. So this was right after the flood happened because we couldn't.
And you had a permit to do that?
We did, yeah. The contractor, which was Donmore Construction, pulled a building permit.
Okay. So what happened? Why didn't you get it complete?
I had mandated flood insurance on all 3 properties I had, and the flood adjuster paid about a third of the claim on all 3 of the buildings that we had. And his thing was, well, we give you that initial amount, and then you file supplements for if you need more money. So they paid about $35,000 on this one, and the damage listing is $66,000. They paid the other 2 buildings I have are on Cooper Terrace, which is right around the corner.
So why didn't it get fixed?
We ran out of money.
Okay.
So
but once you raised it, they weren't occupiable. Is that a word?
Yeah.
You weren't renting either side?
No, because we had to put all new subfloor in, pull the drywall out, and we raised it up and put all new plumbing and electrical in. As you can see the 2 new mastheads up there.
So you had to apply for more insurance money to do that?
They wouldn't pay it. We actually went to court, hired an attorney here, never got anything. So that took another year and a half.
So we're trying to get through this quickly. I have 2 more questions.
Okay.
A, do you have the money to do it now?
I was able to get a construction loan in June to finish it.
Okay, and B, how much longer would it take for you to finish this?
The construction loan gave us 6 months, and I contacted her and I said, when I went to get a permit 2 months ago, they said, I ran into this issue. And so we were supposed to have it done by January. So she said, we can, a couple months. So I would think February, maybe end of January, just depends how the weather goes.
Any other questions?
I know what he's going through. I went through the same thing across the river. Insurance out the whole world.
Okay. Any other questions? Okay, let's close the public hearing.
Close the public hearing.
Did we determine there's no opposition?
Oh, is there opposition? I don't think there's.
Not that I know of.
No.
Before we make a motion,
Oh, yeah,
I want to
our
get
lawyer
an
was
answer
gonna.
from our lawyer so that we're all on above water here. So to speak.
Above water, there you go.
Okay, this is interesting, actually. The board has power under 174180 to look at non-conforming uses. It's under subsection D, and it says changes in non-conforming uses or structures. The board shall determine the appropriateness of proposed changes to non-conforming uses or structures. And then it has a separate section that deals with the situation I think that we have at hand, which I just had my hands on. Let me see. Okay. Right here, right? Yeah. During the period which a property was significantly damaged as a result of the severe rain event that occurred May 1 and May 2, 2010, provided that in no event the period of activity shall exceed 60 months from the date of the damage in order for the property to maintain its status as a protected non-conforming use. This is a interesting piece. One of your tasks is to determine whether or not it's appropriate. That's one of them. The other is difficult to actually characterize because what it really is almost a variance to the code provision.
Right. But that law says basically we do have the authority. We just have to rule it's appropriate.
That if you were to move forward on this case, that is the theory under which you'd have to move forward.
Okay.
Determine that what's appropriate.
That we give him more time to have the use of a duplex. And so therefore I move that we grant him until March 1st of 2016 the ability to remodel this duplex at, where's the address? The 2605 Morgan Mead Drive, and the circumstances were that he only got a third of his money from FEMA. He unsuccessfully tried to sue to get more money, and he now has a loan and he could fix it.
Just to clarify, were you saying to complete the work or to acquire the permit?
To complete the work by March 1st.
Did he have to complete the work within 5 years or just pull the building permit within 5 years?
I think the way that the 66 whatever is probably completed because he's run out.
It doesn't. It's not clear. It's not clear as to whether it
But
has
we
to be
can say
but you can
it has to be
define
completed by March 1st, since we are giving him extra time. So that is the motion.
I second the motion. Discussion?
I'm worried about the time because there's still...
Okay, we could do April 1st, May 1st, whatever you want.
Are you not going to be able to finish in that amount of time?
Yes, you never know what might happen.
Okay,
and
it's...
I would feel better if it was...
You want to do May 1st?
Giving him the time just to get the permit and not clamping down on the construction.
Because once he gets the permit, he has 2 years.
Yeah, that's true.
But your motion, I mean.
I'll give him till September.
Once he has the permit, I think he has 6 months to start and then 2 years to finish. Okay, so
I'm fine with
purposely drag his heels. I'm sure he wants
he's
to
been
get
through a lot already. I'm fine with that. Please put something back on the good taxpayer.
Will that serve your needs?
That will.
Okay.
We want to get it done.
I'll amend my motion that he just has until March 1st to get the permit, and then he has 2 years to finish.
Second.
Any other thought?
Any discussion? All in favor of the motion, say aye.
Aye.
Opposed? Passes.
Good luck.
Okay. Thank you.
Put your boots on.
Yeah, where am I? There.
The next case that will be presented to the board is case number 2015-75. That case involves the Pleasant Hill Church of Christ and their search for a special exception from this board in the R15 district to construct a new church at 3354 Bell Road. First picture presented here to the board is the aerial view of the presently undeveloped property on Bell Road. Second photo, the zoning designation shows that this is RS15 and across the street from a rather sizable AR2A tract, agriculturally zoned, and beside a neighborhood to the north. Site plan submitted from the church just demonstrates the approximate location of the church. The appellant will have the opportunity to add more detail to that. The photos presented demonstrate the views up either end of Bell Road, north and south. View of the subject property standing at the property and looking across into the woods from the agriculturally zoned area and back toward the subject property in the upper right-hand corner there. There is opposition present for this particular case. Therefore, the appellant will have 15 minutes to present the case and have the opportunity to reserve whatever rebuttal time they see fit. The opposition will present their case once the appellant has completed their initial comments.
May I ask a question? Did we skip 72? Did we skip case 72?
Deferred to October 1st.
Deferred. Okay, thanks.
Okay, state your name and you may proceed.
My name is Charlie Jackson. I'm an elder and trustee of Pleasant Hill Church of Christ. I'd like to introduce the other members of our contingency, if that'll be okay.
Sure.
I'm Charlie Jackson, one of the elders sitting back on the right here, the gentleman in the blue stripe, Brother Milt Weaver, one of the elders, and Brother Steve Moore, the other elder, the three elders in the congregation. To the left of me is our minister, Brother Miles Cotham, who's been our minister there for 35 years. We haven't tried to get rid of him, and he doesn't seem to want to go, so it's working out real well. To my right is Brother Dave Lyles, one of the deacons with the congregation, is doing a lot of work on the building program, and to right of him is, to my right, is Jerry Reynolds, the architect for this project. We appreciate the opportunity to be with y'all today and trust the thing that we're trying to envision for the progress of this congregation is something that's beneficial to the city of Nashville and the residents in the area. We started on this project back about 1998 when we started purchase of that land up there. We have paid off the land. Back in 2009, we asked for the special exemption before. As y'all all know, the economy kind of went to pot back then, and so we delayed our plans, and we did have one back then in 2009. I think the expiration on that's like 2 years, so it is expired, and we're asking for a special exemption again. We had a hearing, public meeting, sent out letters on, I got them up on August 20th. I emailed those to Councilman Josh Stites on the 19th, and he sent out about 400 letters to the constituents. Brother David Lyles delivered those letters to Metro on Friday afternoon at 2:30 p.m. to a Miss Debbie Lifesay, is that a name that y'all know? Okay. And then we had the meeting on August 27th. That's Friday. On the following Thursday, we had a big turnout for that meeting. The reason for our request was our present location is over on Council Pike. That's a road that's been cut off by the newest airport runway, and it's become an isolated area, and also it's becoming an industrial area. The new airport runway pretty well cut off the road, so now it's a winding, twisting road. There's an industrial park right across the road from it with trucks going. TDOT's had plans to build another road through there. They've already acquired part of the properties all along that area. And it's got heavy truck traffic on it, but there hadn't been any motion on the actual construction of it. The new facilities on Bell Road would enable us to be in a residential area on a nice road, and we'd have better access to the building for the church to assemble and continue to grow in that area. We had a public meeting on August the 27th. It was attended. We had about 40 visitors. It's kind of surprising we had so many, but first one we just had about 4, so we had a lot more interest that time. We understand Josh Stites sent out those letters to about 400 people on I reckon the 19th one I sent him, or the 20th, but we understand there was a delay in the actual letters that were delivered to Metro in coming out, and some of the people, one gentleman in particular said the letter did not come till 4 o'clock that afternoon, and we had our meeting at 6:30. Thankfully to him, he made a copy of the letter that Josh Stites had sent out and hand-delivered a lot of those to his neighbors. So a lot of those people that came to the meeting were his neighbors that were there. We had several questions at the meeting. I'll kind of hopefully go through them rather rapidly. There was cul-de-sacs. I don't know if it shows on can y'all show the whole property again? There's cul-de-sacs, 2 cul-de-sacs there on the north end of the property. One of them is like Portman, and I forgot what the other name is. But one of the things, we had several questions from people. One of them was, will those cul-de-sacs be extended? We were required to put signs, 2 of them out on the main road, and we were required to put a sign at each dead end of the cul-de-sac, although we had no intentions of extending those cul-de-sacs or even building anywhere around that area, but we were told that we needed to put signs at those cul-de-sacs, and some of the questions had to relate to, was those cul-de-sacs going to be extended, and we told them no, we did not have any plans. In fact, we do not want those cul-de-sacs to be extended because if you do, trucks will drive through your property and destroy your driveways. Their concern was houses would be developed there and the cul-de-sacs be extended, and we said that is not our intention. We do not intend to extend the thing. A second gentleman said he did not want churches in the area. He said he had 3 churches in that part of the country and said that was enough. And so I answered him that some of the churches did not have the same philosophies or beliefs that we did, and we did not want to meet with that particular group that didn't have the beliefs. He left pretty quick after that. One question was they wanted to guarantee that there would be no blasting, and my answer to that was we've done core drilling on one location where they went down 16 foot and didn't find any rock. We don't anticipate going that deep, but we're going to have some more drilling done. We do not anticipate any rock. We will have additional drilling done, and I will send a copy of the report to the gentleman, but we do not anticipate any blasting or anything because we don't believe there's any rock, but anything that we do with the work would require with all Metro, state, federal laws, and also any contractor work up there would have to have insurance requirements. There was a question about trees. The part up there where we're looking at putting the church building is a place where they're fairly new, young trees. It's not an old forest. All the older trees, the big trees, are all back at the back of the property. We do not intend to at any time develop back toward the back of the property. It has steeper slopes and it's not really favorable to development anyhow, but it is a beautiful, wonderful native area that we will enjoy. Of the site, we're looking at about 2 acres for this project out of the 5.5 acres. There was a question about traffic, and anybody's been on Bell Road during rush hour traffic, it's just pretty well wall-to-wall cars, but we noted that times of our services would not be anywhere near the times whenever the heavy traffic was. Our Sunday morning services start at 9:30 on Sunday morning. They let out at 11:30. On Wednesday night, they start at 7 p.m. and 8 p.m. And there's hardly any traffic. Well, some traffic, but not a heavy amount of traffic. Toward the end of the meeting, we had a good discussion. Councilman Josh Stites came. He provided a letter. I'm assuming y'all got a copy of his letter recommending. I'm not going to go in. I won't read that then, but he's recommended the project. Toward the end of the project, somebody asked the question, what would we do if we couldn't build there? Well, if we couldn't build, we probably would have to go build somewhere else. And a young gentleman said, Chris says, it's better to have a church group that will be a good stewards of the property and not extend the cul-de-sacs and preserve the undisturbed area at the back of the property versus the church having to sell to others would extend the cul-de-sac and build on the back of the property. There was one question by a gentleman in the audience here, and you'll see the house on the bottom of the picture. It's got driveways around it, and there is according to the property line, there's a little bit of a concrete driveway that's extended over onto our property, but we do not intend to do anything. We don't want to make any claim to it. That driveway's there and it's going to stay there. So we don't have any problem with that driveway where it is, and we don't make any claim to that. We also will have a buffer area and setbacks that's going to be outside where we'll be doing anything anyhow. I think Miles just say I'm running out of time. Okay, anyhow, that's all I had. Our architect, Mr. Jerry Reynolds, has the drawings. If anybody has any question, but that's all I have at this time. Or any questions?
How many in your congregation?
There's about 80 people in regular attendance there on our Sunday morning services. So it's a small congregation.
And what hours of the service? Do you have Sunday and Wednesday, or?
What are the times of the service? Mm-hmm. We have service on Sunday morning and Sunday school at 9:30 and worship service at 10:30. We have another worship service on Sunday night from 6 to 7. Then we have a Wednesday night Bible study that goes from 7 to 8. And anybody that's in here or anybody that listens to this is welcome to come anytime they want to.
Any other questions? You have anything further to add?
That's all I have, unless y'all have any. Anybody? Jerry, did you have anything you want to present?
What we're trying to do is 216 seats in a multi-use room, and we have 54 parking spaces, which is the code variance or code requirement, and that's what we're showing on the plan, which is the same one that's on the board up there, but this one's been colored up so you can see it a little bit better. So basically, it's just a small development.
Okay. No further questions. You'll have like 4 minutes and 24 seconds for rebuttal times. You have opposition, so you can come back up after that and address it.
Let's hear from the opposition.
Thank you.
Okay, state your name for the record.
I'm Mitch Camp. I live in the home just south of that property. I've been leasing that property for 7 years, and I also just recently talked to the Colsons, and I'm also representing their interests in that property as of now, because Bill Colson is in hospice right now. He may not make the week, so the family has been diverted onto other issues than this issue. And I'm a prospective buyer of the property.
My name is Mark Hull. I live at 3368 Bell Road, which is 2 houses to the north of the property.
And my name is Donald Easton. I live at 3109 Harborwood Drive.
just north of the property, about three or four parcels removed.
My name's Morris Alexander, and I live on 2000 Lake Court. It's just north of the property. I live on a cul-de-sac. I guess it'd be like the fourth cul-de-sac.
I'll speak first because I think I'll be brief. I was really hoping this was going to be at 1 o'clock today, so.
We feel your pain.
Yeah, well, and my pain really is in the process of trying to gather information. You know, I get this letter in the mail for a meeting that's happening that night at 7 o'clock, and I couldn't make it. I didn't make it. So I don't know what the exception is. I don't know what the variance is. I don't know what the appeal is. I really don't understand the whole thing. So that's why I'm here to gather information. I now have a lot more information. Well, I'm more comfortable now, but I didn't know that until I came here.
First of all, in the way our zoning works, there is no zoning for church. There's not a church zoning, so all church projects have to get a special exception, which is why we have these hearings. Now, as far as the late notice that the appellant has mentioned also, would you feel better if you had an opportunity to meet with them again?
Yes, in fact, I met with them, voluntarily, seeking information. What is your plan? Show us what your plan is.
And that's why we have those notices. And what I'm asking you is, would you still like an opportunity to have a formal meeting? Would that make you feel better or more comfortable with the process?
What he's implying is, do you need more time to talk to them outside of today?
No.
Okay.
Okay.
No.
I'm sorry, go on.
So that's really it. I just really came here to seek information and clarification.
Are you in opposition to this? And if so, why?
May I speak?
I'm undetermined at this point. I am in opposition to the process of information being disclosed and the ability to respond.
Okay. The other neighbors?
I was in opposition to if there's going to be any blasting, okay? But apparently they have done some core drilling, but the core drilling is being done on the north side of the property, and they're actually going to build on the south side towards the road. And once that core drilling there is done, if they have the same luck as they did on the north side of that property, which they went about 15, 16 feet and didn't hit rock, that would be a wonderful thing, because that would mean, guess what? They wouldn't have to do no blasting for sure. But unfortunately, they planned on putting the church at the north side of that, and they've decided now they're going to put it on the south side. So if they could do that and assure me, I would not be opposed to it.
All right. I'm in opposition only mainly due to the lack of information. I have not been notified of any of these meetings. I do not live in the neighborhood north of that property. I'm in the house south, and I have not been notified of anything. So I'm not 100% sure exactly where buffer zones are. I just was introduced to, Mr. Jackson just introduced himself to me here, and he said that they're not going to dispute the boundary line dispute that we have, because that little line was a recent line made by a recent survey, and the dispute is that that line does not belong there, and we need a surveyor to come out to the property to survey our property in order to move that line over.
So as proposed, do you have any objections with their project?
I would like to meet with them in the future, and find out.
Before we do something, or
afterwards?
Okay.
You asked him that question,
yes.
And I was nodding yes, because yes, I need more information in order to find out what's going on, so that there's not a parking lot right up against our driveway. Mr. Jackson did say there'll be a buffer, but I don't have a picture of what that would be, and it would dramatically reduce the property value if the parking lot was too close to the property, our property. So that's a concern.
We have the urban forester here who maybe could address the question about the buffer.
Yes, churches that are going into residentially zoned areas such as this one are required a B-type buffer. And that pretty much means 20, 15, or 10 feet of buffer material, shrubs, trees along the property line.
20 feet in depth or?
Width, not length. Length of the entire development.
And minimum of 10 feet, really?
Minimum of 10 feet.
That's a lot. So the applicant knows that and they're going to comply?
I would assume so.
Okay.
So the issue with that is that line there is 10 feet well past any tree line that exists. It's in the middle of the driveway, so if there's 10 feet, that means there really won't be any, there will be no buffer zone between the properties.
No, they'll have to.
That means they get to plant a 10-foot buffer.
Yeah, basically, I would like to just have more time to talk to them about it on the record.
We have one other case today, do we? Two more cases. If you want to, you all can go back and chat with them and see if you can get your answers or whatever, and then come back and we can resolve this today if you'd like to. Or,
and if not, we can defer it.
Yeah.
Do you want to try to talk for a while?
Sure. We can. You guys opposed to that?
That's fine. No. So
that's good. That's a good idea.
We can put this case on. What do we call it?
We'll heal it, and then we'll come back to you all. There's a room back there, too.
All right, sure.
It's open.
Okay.
Thank you.
Sure. So call the next case.
That's going to be a quick one. As we proceed to the next case that's scheduled to be heard by the board, I will ask, is there any opposition present for case number 78, which is located on Woodley Drive here in Nashville? Asking again, is there any opposition present for the case number 78 on Woodley Drive here in Nashville? Seeing none and hearing none, Mr. Vice Chairman, I would suggest that as this was originally identified for the consent agenda and seeing no opposition at this robust hour in our afternoon, this would be an appropriate item for the board to take action on without a public hearing.
Yes, I move that we move it back to the consent agenda.
Okay. You all hear that?
Did you hear that? I move that we move
this case, and originally we had scheduled for consent agenda.
No,
78.
I don't think it was on the consent agenda.
No, because someone objected, and they're not here anymore.
I had questions.
Okay,
Are they here?
yes, they're here, ready.
okay.
Come on down. We will hear your case.
Well, I mean, there was opposition in the board packet.
It's your call as a board member.
In the absence of opposition in this room at this time, the applicants or appellants will have 10 minutes to present their case. If they wish to use that amount of time, they're of course more than welcome to do so. The board will then have any questions they have, and in the unlikely event that anyone were to show up with opposition, I guess we would field that at that time.
Well, John Michael, let's go. We'll hear the case.
Case number 78 is located on Woodley Avenue in West Nashville. The request is for a variance from setback requirements in an RS20 district for the subdivision of the current parcel. It's been referred to the board under section 17.12.030. This is item B, variance appeal. The overhead shows the condition of the property presently. The zoning map shows that it is in fact RS20 district in an established residential neighborhood. The site plan submitted by the engineer shows the plan, which they'll be able to detail in much greater detail than our limitations with the PowerPoint here. Photos show the subject property in its current state. In the lower right-hand corner, the view across the street. This pair of photos just shows the street that the property faces to the, I believe, north and south, but either way up and down Woodley Drive. With that, we'll hand it over to the appellants.
Thank you, members of the board. My name is Jay Rosenblum. I'm the authorized representative of Woodley Partners, LLC, which is managed by Carrie Rosenblum, sitting to my right, the owner of the We are here to discuss a variance, I guess, a zoning variance to push to pull the setback from 80 feet to 60 feet from the road.
Sure. And so why you need that extra space?
Exactly. We have a hardship here. Well, first of all, two things. I wanted to, if I could just get in before that real quick. Our civil engineer, Jay Fulmer, is out of town, happens to be out of town this week. But he has provided us with some information that he wants us to share with you. Also, there are a number of neighbors that actually have adjoining properties that could not be here, but they did send an email, and I know that may not be admissible, but I wanted to let you know that...
That's admissible.
Okay, good. I wanted to let you know that at 1:41 today, William Hastings, an architect...
The architect?
Yes, an architect who is directly behind this property, wrote me and said, I can't stay. He was here earlier.
I saw him, yes.
I can't stay. I have a meeting. You can... And he's sort of been our guy that we go to for the neighborhood. And I'm quoting, you can represent that William Hastings, him, Jeff Haynes, Travis Hill, and Jeff McLaren are all supportive of this request. We had conflicts and could not be here today. We have met with Councilman Holloman, by the way, who is no longer a councilman there, and I've also specifically spoken on the phone with Councilwoman Kathleen Murphy, who is new to the whole thing, and it was just really, beyond what her knowledge at that point as well, and there are no issues. Is what he said.
Okay. So why do we need the extra space?
We need the extra space because there are 6 acres of drainage that are coming to the common property line from Mr. Hastings' property, which is just to the, I'm not sure directions. It's in the back of the
pool.
Yeah, directly behind. Yeah, directly behind the pool. And we met on site with Mr. Hastings and also with Mr. Haynes, and they showed us what was going on their site. If we're able to do this, then more of the existing vegetation can remain if we can slide the houses forward just a little bit to provide room for the storm water routing in the way that Mr. Fulmer has drawn it on his drawings, which I think you all have. Our neighbors encouraged us to do a zoning application, and they have been in contact with planning about this process. During the subdivision process, it was examined whether the setback could be reduced, and the zoning and planning directors, Bill Herbert and Doug Sloan, suggested a variance be applied for the reduction because the plat cannot reduce setbacks. Also, at the back of the property that we're talking about here, there's a berm underneath the vegetation in the rear, and it directs the stormwater in a manner that limits rerouting options. It's beneficial to move the houses up to provide for a better scenario for the rerouting. As of right now, the properties that are, if I'm looking at that are below that property right now, and we saw this with our own eyes, they're flooded when parts of them are flooded when there is heavy rain. What we're proposing to do is to do 2 things. One is we're trying to alleviate some of that from what they have in their property, and secondly, also to preserve the vegetation, the mature vegetation that is around the entire property and allows enjoyment by all of the neighbors.
Okay. Do you have any questions based on that?
So I think what you're saying is this new development is going to improve the stormwater quality in that
Correct.
area? Okay. It all was not clear in our board packet.
Sorry. Yes, it is going to improve the stormwater.
Does that relieve all your questions?
I think so.
So it looks like, if I'm reading the plan right, that the new setback is approximately where the building to the north covers, that's about the 60 foot.
Yeah, and in fact, I forgot to mention, although you're the ones who determine the relevancy, but yes, the house to the north is at a 60-foot setback, and the house to the south is actually at a 30-foot setback. So there will be two homes on these two parcels, and we're trying also to continue to meet with the spirit of the neighborhood and the outline of the neighborhood. It would look probably somewhat unusual to have a 60-foot and then two 80 feet and then a 30-foot.
Okay. Anything else? Okay. Any other questions? Any other comments?
No, sir. No, sir.
Okay, let's close the public hearing.
We'll close the public hearing, open it for discussion. Entertain a motion?
I move that we approve case 78 and the variance in the setback requirements for RS 20 based on the water issues of the rear of the property and that being the hardship.
Is there a second?
I'll second.
A motion and a second. Any other discussion? All in favor of the motion, say aye.
Aye.
Opposed? So moved.
Good luck.
Passes.
Let's take our West End people.
Thank you.
Since the other people aren't here.
We'll proceed to case number 2015, number 79, located on West End Avenue. This is the former Welch College property, and our appellants on this case, DJ Ferris on behalf of the appellant Mike Ford, Custom Classic Homes, owner and appellant on this property. They're requesting a special exception from certain setback requirements in the RM40 zoning district as part of their development seeking a 32-unit townhouse development. It's referred to the board under 17.12.035, Part D, Part 1. The jurisdiction for the board is under the special exception criteria at 1740-180 subpart C. The photo here in your packet demonstrates the aerial showing the property with its relative proximity across the street from the West End Middle, I guess it is, and near 440. Zoning map shows that the front part of this property is zoned RM40. The rear portion along Richland has various zoning designations, as you see, near where this intersects with Bowling. The site plan shown here shows the multiple phases contemplated in the development over the long run, with the emphasis being on the first portion nearest West End. An additional view of the site plans here. The photos here show the proper placement of the signs on the front end of the property at multiple entry points, view up and down West End, and directly across the street there on the right at the church across the street from the property. Because there is opposition present, there will be 15 minutes allotted for the appellant in this case. They can reserve as much as they like for the rebuttal. After the presentation, any questions from the board, the opposition can come forward and present their story.
Okay, you can proceed. State your name and your case.
Thank you, Vice Chair. Good evening. DJ Ferris. I am with Cisco and Ferris. My business partner and I have a brokerage firm, and we were fortunate to work with Land Innovations on behalf of Welch College and now Mike Ford on the redevelopment of the campus at West End, and that is why we're here today to continue in that discussion. Specifically, this is continuing a conversation that we began in May, and I met with Bill Herbert in May, and we're seeking a special exception on the front setback and rear setback of 2 feet. And I will want to demonstrate to you that that does not adversely affect the neighborhood, as well as, number 2, that it really encourages a strong pedestrian-friendly environment. And I will be glad to show that to you now, or probably would like to reserve probably some time for rebuttal and discussion later. And maybe as you have questions, I can demonstrate the answers to those 2 thoughts.
You have the support of one of the older neighborhood associations in Nashville, Richland West End, correct?
Yes, sir.
Tell us about that, and that's a tough crowd over there.
What before I speak broadly, I must thank one of those members, Mr. Charlie Cook, who has shared in his afternoon to be here and to voice his continued support. The college had tried to sell their campus for 23 years.
A lot of people have tried to do what you're doing here.
Yes, and as you can, I want to first say I'm fortunate to be one of the junior members on the team that has gotten to be that group that put it together. It was every turn at Metro was supportive. Every department helped us to think about it. The neighborhood you speak of, we went right to the neighborhood immediately, at the forefront, with the listing brokers of the campus and with Councilman Holloman at the time, and consensus just continued to build and build and build. Had at least 2 neighborhood meetings that come to mind regarding the whole project. This aspect was mentioned in a neighborhood meeting on May 21st, after Bill and I first met about it on May 15th. So the neighborhood, I can't say enough about Jim Kelly, and whose letter I have. I believe that they've sent you all a letter, and I have copies of that letter to leave.
We have that.
Wonderful, wonderful. And so that was certainly, yeah, you're right. No, this is not done without the support of the neighborhood. Yeah.
So anything else to add? Tell us why you need the 2 feet.
The 2 feet allows, as I said, for the brownstone site, which is what Mike Ford is pursuing in this moment, to really encourage a strong pedestrian-friendly environment. And the 2 feet allows for the brownstone building and construction to be in more smaller scale, to have the architectural relief that is conducive to that architecturally pleasing feel. Instead of just a straight shot down West End, it has that gentle relief that we believe will be supportive and has been supported by the neighborhood as making sense. And yeah.
Okay. Mr. Cook, do you have anything to add, or we appreciate you being here?
I appreciate the opportunity to be here. I'm Charles Cook. I'm a resident of 3608 Richland Avenue. I live right next door to the girls' dormitory, which is on Richland Avenue, and across the street from Davidson Hall, the school, Wells College Auditorium, and the Student Center. So I'm got 2 sides of the 4 of my home encompassing around the college. As DJ pointed out, the school has been working for 23 years to sell this property, and a number of developers and other institutions have looked at it over the years. And this is the first opportunity that this property has had to really be developed in a very first-class way. And I think a 2 feet easement or a variance on West End and a 2-foot easement or variance in the rear of the property is not going to have an impact on the street scene going down West End. I think it gives them an opportunity to make the buildings more architecturally appealing, and my wife and I are very much in support of this.
Thank you. Do you all have anything else to add before we hear from the opposition?
We could discuss more. I'll leave time for the opposition now.
Okay.
You'll have 11 minutes, 25.
Yeah.
For rebuttal.
That's right.
Okay.
Yeah.
Let's hear from the opposition.
Can I ask John Michael a question while we switch here? There's something in the paperwork about there being a 39-foot required setback. I just want to make sure. Maybe I misread that. It's only 2 feet is being requested, both at the front and the rear.
That's my understanding, and forgive anything that's been left unclear in the documentation, and also forgive me for not being able to speak to that specifically, as I handed off my copy a moment ago.
Okay, thank you.
Please identify yourself for the board and tell us why you're opposed to the project.
Sure. Thank you for letting me speak today. I'm Margot Chambers, and I live at 3803 Princeton. I'm in the Richland West End Neighborhood Association, and I'm an active board member also of the Neighborhood Association. Our neighborhood board has not met to discuss this particular setback request. The site plan we have is dated July 17th. That's what's in your packet, which came after the general meeting that we had on the 21st that was mentioned. We also didn't agree to forego any required neighborhood meeting as Mr. Ferris requested to Mr. Cook. Mr. Cook is a really good man. He's a longtime resident, but by his own choice, he's told the board he's not on the board of the Neighborhood Association, and he hasn't come to any board meetings in a long time. We have about 30 board members and about 20 actively participate. Less than 10 emails responses were given in support of a letter that Mr. Cook wanted, and we presumed we'd been given an up-to-date site plan, which I think has changed. I was hoping I would hear more about what was here today, but maybe I'll find out more in the rebuttal. Even though the letter was written, it addressed a preference for townhomes over condos, and not whether the group approved of a less wide alley or whether there's room for parking. And I share the same concerns about this development as my dear neighbor, Mr. Cook. But he's worried about fear of more condos than about the facts that are in front of you or the facts that you're supposed to decide upon. And I wanted to make sure that you have all the changes made to the lot lines since the July 2015 site plan was shared with some board members of my neighborhood association as it impacts any setback variance. And Mr. Ferris, I've noticed in the notes that you say before you today, alleges the board is jurisdiction under 1740 180C, even though it was referred to the board under section 1712 35D1. That would be another situation not presented to any board member of my neighborhood association. So I'd ask you to defer this until a true community meeting can be made aware of this request. If that new jurisdiction request has something to do with height, as I heard in another request today, there is a 35-foot height limit on West End, and it's called the Tennessee Scenic Highway Act. And the state recently reaffirmed this ruling when it was challenged a few months ago. I have concerns whether there's enough space on the lot for the setback request and still have room for emergency service vehicles to access a new alley that has yet to be created, whether the lot lines defined in the Declaration of Reciprocal Easements and Covenants filed by Mr. Ford on August 3rd are reflected in the site plan before you. We saw a site plan dated July 17th, and the letter was based on that version that you have. I'd like to know whether the lot lines defined in BL 2015-1312 are reflected in the site plan. This is the land to the left portion of the townhome development. It's for water easements. And I wanted to know if the setback measurements in the site plan include any parking space, because we couldn't really tell. I'd ask that it does not include parking space for any setback request. I wanted to know why the site plan has 2 front sidewalks. I think 1 front sidewalk would be enough. So there currently is a front sidewalk, and it looks like the developer wants to add a second one. I want to know if this setback will comply with 2015-1267, which is a historic landmark overlay on a portion of 3606 West End property. It includes a back lot line next to a new alley, and keep in mind the final plat approval for another 3 lots on Richland, which backs up to this new alley, was made at the Planning Commission on the 10th of September. So I want to make, and those all reference lot lines, I want to make sure that there's enough alley width for emergency services, whether, I hope I'm not reading the second page again, whether there's, you have enough parking spaces in the front and the back. It affects our quality of life and character of a historic neighborhood. And let's see, we don't really understand the front setback, what's there, the landscaping. It looks like a new parking space to some, a second sidewalk. To others, it looks like landscaping. And we're just trying to figure out where there's a curb cut. And so we'd like you to ask the developer to resubmit an updated site plan showing the curb cut or the new landscaping and explain the need for 2 sidewalks. And if it is 2 sidewalks, which one's the setback? That would be another question. It appears to us that there's less than 28 feet from the building to the front curb and less than 19.4 feet from the building to the back lot line. And that's all I had to say. In addition to the proposed amendments to the BZA regulations that you'll make next, could you, that's going to give property owners 600 feet notice. Could you consider better defining what constitutes a neighborhood meeting, including possibly submitting a sheet of signatures of owners who were in attendance? Thank you.
Thank you. Anything further you want to add? Okay. Fellow, come back up. You want to address our questions, concerns?
Anything related to the 2-foot special exception under the UZO that we're wanting to discuss today, I think I'll be open to discuss in my 11 minutes. And I'm trying to recall exactly what all was said in.
And if we approve your plan, you have to go through traffic and parking, and they'll talk about emergency vehicles. They'll
Right.
talk about, the number of parking spaces for this type of unit. So that's not our venue here.
Right, yeah, and this is, and the site plan before you is nothing that's been submitted for final approval. This is something that was discussed as recently as Tuesday with not this specific site plan, but I discussed it on Tuesday with Bill Herbert, what we ought to show, and then we discussed in our own office of let's show what the setback from the current sidewalk, or the back of sidewalk, would be at 30 foot and what it would be at 28 foot, and that's what you see before you. So I'm trying to keep this very straightforward for our purposes and time together today, and there's certainly a forum, I'm sure, to talk more specifically to the development as a whole, because there's a lot more discussion to be had.
Anything else to add on rebuttal?
Again, I would say this falls under the UZO, and it really seeks your approval for this 2-foot special exception. The zoning would allow for 69 units for condos. This has, speaking about the rebuttal, this has nothing to do with the height. I'm trying to stay on topic here. You could, if you want to talk about, I think some of the less I say, the more, that's all we need to discuss. I don't want to take any more of our time. Any questions, though? Is there any questions you all have? Because that's what I'm more concerned about.
Perhaps you could address the question that we had about the required street setback 39. This is on your permit tracking sheet. Could you enlighten us on that?
39?
I think that's the question that John Michael was asked. So was that erroneously?
That must have been erroneously included in that report. Sorry, I don't have the document in front of me at this point.
Yeah, it's.
So that's incorrect.
Yeah, the front setback is 30 feet. We're asking, and that's something else to discuss.
You're asking for 2
feet, and it's not across the whole front. We're willing to pay the fee to have that flexibility, but we proposed at one moment 30 brownstone units. Now it's looking like it'll be 26 brownstone units. This is for, if we just got the 2 feet and did all of them at 28 foot, then we reach the same result. So there's going to be some units that will be at the existing setback. The 2 foot is just to allow, as you see there before you, some variation on roughly half. It may be a little bit more, but that's, again, to be determined, and will be
Okay. Any other questions?
Could you respond to our question about why 2 sidewalks?
Yeah, it's a good question. I'm actually going to read the text message from the architect, who is for Mike Ford, and this is kind of what I had felt, but this is with much more clarity. And it's just to have more continuous buffer between the brownstones and West End, and otherwise we'd have 13 little sidewalks going from the brownstones all the way to the to West End. Mike has really emphasized that he wants to have a strong lawn amenity for these new residents, and West End is a busy road, and we want to just have that buffer, and those two sidewalks that design encourages that.
Okay, any other questions?
Let's close the public hearing.
Close the public hearing. All right, we'll open up for discussion.
As I said, and it's impressive that after decades of somebody trying to get this property developed and running into numerous roadblocks, and many from the neighborhood, that we have a letter from Richland West End Neighborhood Association signed by their president on September 3rd saying that they support this variance. So to me, that speaks volumes, and this seems like a plan that fits within this neighborhood. And for that reason, is there any more discussion are you all wanting a motion? Okay. For that reason, I move that we approve item 79, that it meets the requirement of 17-12-035D1 of special exceptions for a variance from the setback requirements in the RM40 district, and does not negatively impact the neighboring properties.
I'll second that. Any discussion? All in favor of the motion, say aye.
Aye.
Opposed? Passed.
Good luck. It's been a long time coming.
Thank you all, and thank you to this young lady who has worked so hard all day.
And I'm very happy that Welch College, the former Free Will Baptist College, will also be able to continue to educate in the city.
Yeah, amen. Thank you.
Actually, they're going to educate in Sumner County.
Sumner County, our loss, Phil. They will do well.
Okay, we'll call back,
I'll see you later.
let's call back to the
Oh,
other.
I know, but we have quorum now, so I'm
Okay.
ready here. Go.
This is case number 2015-75 Pleasant Hill Church. Is that the one that you guys took a break, come back up?
Hey, David Ewing,
David,
we won't have a quorum if you leave.
I didn't.
But you didn't hear the first part of the
case.
case. Well, this won't take very long.
Enter stage left.
Command.
I forgot, she wasn't here.
An encore. What did you all decide?
Welcome back.
This is Mark Hull, 3368 Bell Road. We are not in opposition to the plan as it is now. I'm not, Don Easton is not. I don't believe Mr. Alexander, are you in opposition to the plan now? I'm fine with it. You're good. I don't know about Mitch, the one that lives on the south side as opposed to the north
Well, let's
side.
hear from him.
We came across an agreement, provided the agreement withholds, then everything is okay.
Is that an agreement that we can make in a motion?
The agreement is that the boundary that takes part of our driveway, the garden, my garden, and my raspberry bushes is not disturbed. Okay. And that we're notified when the superintendent and the construction comes so that we can be there to make sure that there's no misunderstandings and they don't start plowing over our driveway.
Well, we really appreciate you, for staying for such a lengthy meeting, and we also really appreciate you sitting down and discussing and coming to an agreement. We wish we were so minimal sometimes, but you've done what we have not done sometimes, so well done.
My pleasure.
And so let's...
So that will close the opposition.
Yeah, so there's no more opposition.
Appellant back up.
Should we bring the... So let's bring the appellant back up.
Yes, we need to do that.
The appellant? So it looks like you have reached an agreement with your neighboring property owners, and that I guess the one sticking point was that the immediate neighbor to the south, that you do not disturb his bushes, fruit trees, etc., and that you notify him before any sort of work starts. And I'm sure you have exchanged emails or cell phone numbers for that.
That's correct. And one of the things he'd mentioned, he did not receive a letter. There was a complaint. He not being the property owner, they didn't send a letter out to him.
Yes.
Metro didn't send a letter out to him, so that's why he didn't. But as soon as he buys the property, he'll start getting letters.
But you all can notify him right now.
Yeah, he'll start getting
Get his
letters.
address, notify him, get his cell phone number.
Yeah, we got contact to make with the people doing it. But once he owns the property, he can start paying taxes like the rest of us. We're going to leave Mitch Camp's garden undisturbed until time to harvest the crops, and then we will help him.
Okay. Okay. Anything else to add?
That's all. Thank you so much.
We'll close the public hearing. Open for...
Make a motion.
This one.
Okay, I move that we approve the special exception in case 75 on the R15 district to construct the new 7,400-foot church, and that the neighboring property to the south, the shrubs and fruit trees will not be disturbed by this new development, and that they will notify the occupant and future owner of this property before they commence any work whatsoever on this project.
Wasn't there a driveway consideration that the driveway would remain in place?
His driveway is actually over on our property. But we're going to have to have a buffer zone anyhow, so we don't have any intention.
That he will still have use of that driveway.
Yes, he'll still have the use of that driveway. We don't have
block him from using that driveway.
We don't have any intention of causing a problem with that.
Yes, we're including that in the motion.
And we have a buffer zone there that will be outside his driveway.
Good. Okay.
I'll second that.
Okay, you've heard the motion, second. Any discussion? All in favor say aye.
Aye.
Opposed? It passes.
Now, John Michael is standing between us and the door and has some, now you all are done, so congratulations. Thank you again for being
Michael,
reasonable and staying through our long meeting.
She was not voting on that
Yes.
case. So it was 4-0.
That's it. So John Michael, help us out here.
To conclude our meeting today, members of the board, we have two items still on the agenda. First is a request for rehearing of case number 2015-12. Seeing that there's literally no one left in the building that's not been addressed, that person is not here, and it's appropriate for the board to dismiss the request as was submitted to the board.
I make a motion that we dismiss that request.
Second.
All in favor? Aye.
That dismissal passes 5-0. The last item is a proposed amendment to your BZA rules and regulations. Under BZA Rule 9D2d, we require folks who are seeking special exceptions to present notice to owners of neighboring properties within a 300-foot radius. Because the Metro Code changed the rule with regard to notice of the case in general to a 600-foot radius, we're encouraging the board to adopt a similar adoption so that the two are kind of in lockstep, so that anybody seeking a special exception in the future will need to have a neighborhood meeting for anybody within a 600-foot radius. With approval of that, I'll make the amendment to the board rules, get the signature, and submit it to the Metro Clerk accordingly. Staff seeks your approval of the rule change.
Is there a way that we can do this so that the property owners and the residences themselves can be contacted?
To the direct answer to your question is yes, there probably is a way. The more pragmatic answer is we typically don't have a great opportunity to accurately identify the
tenants in rental properties or unknown residents sometimes in properties.
So the renter may have a post office box or something like that. And you don't have a record
That is
of
sometimes the case. Our safest bet historically has been to go by the ownership of the property, and it's what Planning Commission has always done
I
as
guess
well.
that's what the signs are for.
That's the idea.
Exactly.
Okay, thank you.
Okay, so motion?
I move that we change our zoning amendments to comply with the increase of distance to 600 feet.
I'll second it.
All in favor
Discussion?
of the motion, say aye.
Aye. And the last bit of breaking news while we've been in this very lengthy BZA, Mayor-elect Megan Barry's inauguration will be on September 25th at 2 p.m. at Public Square Park, home of the wildly popular Live on the Green. So all Nashvillians are invited to come and see the change of power and our new mayor sworn in on the 25th at 2 p.m.
With that, I guess we can adjourn, right?
On the stroke of the gavel by the Vice Chairman, we'll adjourn.
Adjourn.